It appears that we are live, people. All right. Welcome everyone to this is the first episode of Saturday Night Live Stream with three lawyers. Now we've done a four-way live stream on a random Monday afternoon with Leonard French and the odd three people you see here right now. If Leonard French is watching incidentally and you ever want to get in, let me know in the comment section. I'll send you the link and we'll bring you in. It'll make it perfectly symmetrical. You know, three is nice, but four squares is beautiful. Now, everyone says hello. You're late. We were late. We're just getting the rules set up for tonight's live stream. John Stewart, yay. Okay. While everyone starts streaming in, because we had 50 people waiting, which was, I think, almost a personal record. While everyone streams in, we got... okay, I'm going to bring up some people here. Lemon GF. I'm friends with him on Twitter. At least we follow each other on Twitter. Sky Daver. I have no money. This is the only time I will be heard. I didn't even see that before I brought it up. Sneaky the Lost. Okay. And we got Stephen Guatkin. The content for this ridiculous impeachment is great. We'll get there. We got John Stewart. You're great. Thank you very much. Colin Bowling. Viva, we hear you. Awesome. That's good to know. And Raytheon. Heyo. Hiyo. Okay. Jane, well, let's just see what we got here. James P. FP. VF's reminders are the best reminders. Okay, it's a fact. Okay. Well, sorry, I shouldn't do that into the camera unless anyone's into ASMR knuckle cracking. Okay. This is Saturday Night Live Stream. We've got three lawyers here. Hourly rate, easily $1,000 per hour for this live stream, which is value added to the internet community. I won't ask, actually. I should say I'm probably the cheapest of the bunch. So we're gonna first of all, I'm gonna introduce Nate and Kurt properly in 2 seconds. The rules are we're gonna discuss things. We're gonna talk. It's gonna be more conversational, more meandering than regular videos, regular streams. If you don't like that, you can express your discontent. It may irritate me to read it, but I'll read it nonetheless, and you're entitled to your opinion. It's going to be meandering. We're going to talk about the impeachment. I want to talk about Willie Nash because that's been driving me nuts since I did the video. And Kurt wants to talk about Brexit, and we'll talk about other stuff. So that's how it's going to go. I'm going to read the super chats, not in a manner that interferes with conversation, but in a manner that ensures that I don't forget to address super chat, such as the first super chat, the real Bambunga, robot roll call. Don't know what he means. Bambunga, thank you very much. I see the real Bambunga often during the live streams, and it's great to see repeat offenders, so to speak. Okay, order, left to right. Nate, Broady, middle of the screen. Who are you? What do you do? What's your channel? Post a link when you do this, and everybody, welcome to Nate.
Hey, my name is Nate Broady. My channel is called Nate Broady, so it should be easy to find me. It's literally spelled the way you see in the little box down here. It's funny because I'm trying to find. There it is, the box down here, there. You know, I am a lawyer. I've been a lawyer for a little while now. It's interesting because I really love the profession, but I like the more or less the academic part of the law more than just the adversarial part of it. You know, I love learning about different aspects of law and different types of reasoning. So my channel is just really about law and really how it just evolves kind of in everyday lifestyle. Like, for instance, my next video is going to be on the law of strip clubs and how, you know, each individual municipality treats it differently and how the Constitution has addressed the issue of whether, you know, women who strip in particular gentlemen's clubs, if that's a constitutionally protected right. So, you know, that's kind of my little twist on things.
Very cool. And full disclosure, Nate and I have done multiple live streams. I think most of you already know that. One of the first live streams I did was with Nate, where we got into a lot of his personal life, and it was fascinating. It's one of the few live streams my father actually watched. And he said it was one of the best live streams or interviews, you know, he had seen. Amazing story. I'll try and post these links in the pinned comment with the channel so everybody can get to them for ease of reference. Nate, welcome. Let's do this. Uncivil law. Kurt, who are you?
Yes, I will post my link in the channel for those who want to follow me on my channel link. You can visit me there. But my name is Kurt Mueller. I also go by Blackleaf. And of course, the channel name is Uncivil Law. My day job is as a patent attorney, or is that patent attorney, depending on which part of the English you're using. My specialty is in electronic technologies, computer interfaces, and back-end database systems is what I do on a day job. And much like Nate, I like the academic side of it. I love studying stuff. I cover pretty much everything on my channel just because it's a great way for me to learn and find out what's going on and keeping sharp. It's my own private CLE in addition to what my bar requires. And, it's just a good way to keep up what's going. And one of the things I really like is this law community is growing, and we have 10, 11, 12 voices out there now between the different people. And we have a wide spectrum of thought, from left to right, from different ideologies, different ways of perceiving things. And so it's the new academy is what I think this is. So I've appointed myself a professor. We are now a member of the academy, and that's what we're doing now. So that's who I am.
And it is amazing, actually, because it started off as, I think Legal Eagle was the first to really establish a foothold in the YouTube law channel community. Then you had, if you have Ian Corzine, I'm going to drop a bunch of law channel names for anybody who's never heard of them yet. And guys, drop in more if I'm missing any. Ian Corzine, Legal Eagle. Mm-hmm. You got Hogg's Law.
Hogg, yeah.
You got Requieta Law.
Yep. Requieta.
You got Leonard French. You've got Uncivil Law, Nate Broady, Viva Frei. Who am I missing? I know
Steve Leto. There's that woman, Christiana Hall. She does a lot of freedom libertarian law stuff.
And what's the guy, Lionel something or other?
Oh, yeah, Lionel Lore, YouTuber law, who has disappeared off the face of the earth.
I thought someone was going to say Lionel.
Wherever you are, I want to know that you can come back at any time. We love you, man.
I thought someone was going to say Lionel Hudson. That would have been a funny punchline to
Lionel Nation. You're talking about. He's from New York. Lionel Nation.
I don't know him.
You would know him. He's pretty famous.
Okay.
Now hold on a second. We got Dylan Killen, which says the Frei guy, bonjour mon ami, which means hello my friend. Comment allez-vous, which is French for how are you doing? Très bien. Et vous, Colin? Dylan, not Colin. Okay, so this is very cool. First of all, we're at 575 people now, which is great. And we're about 7 minutes in. Everyone's got the intros. Anybody wants to timestamp this, that would be the surefire way to get a pinned comment, because I can't do it afterwards. It's just too much to do. Not So Slim Jim, thank you very much for the super chat. He says, do a video on Olmos Park and Leon Valley, Texas. That would be a straight up learning curve for me, because I don't even know what that is. Do you guys know what that is?
Not something. No.
Okay, so we're gonna screenshot and come back to it. But tonight, Lito's Law. Lito's Law, very good. Thank you very much. Nope.
Lito's Law too.
Lito's Law YouTuber had a death in the family and is taking a break from YouTube. Yeah, Lito's Law is great. I watch it. It seems to be oriented on cars for some reason, or I don't want to say that in a demeaning manner at all. Period. It focuses a lot on legal issues. He's from Michigan, so there's a lot of car stuff to it. And in his backdrop, there's a lot of car stuff, which is, I think he has a passion for.
Yeah, he does lemon law.
Yeah.
So it's very cool. Lito's Law is another great one who does like the sort of live stream type field videos, and they're fantastic. Are you three Republicans? Good question. I said this before the stream. I know Nate personally for a little while. I know Curtis, but not politically, or not politically. So I don't know how he stands. I don't even know how he stands on the impeachment. So we're going to get into this in a second, because it's going to be very good. John Schneider, thank you very much for the super chat. Okay, where do we start?
Well, just to be clear, I'm not a Republican. I'm an independent, but I do vote for Democrats. Oh, you see it? That's when the light's going off, because it was just making sure. I was like, just be sure.
This is me making sure that he does not get into trouble.
No, but just to answer the question, I voted for Republicans and Democrats. For me, it's really about kind of the time and place. I'm just not one of those absolutists. But I have, to be fair, I have voted more for Democrats. But that's obviously because I live in the Northeast, and most of the people who are winning up here are going to be Democrats. So you have no choice. So.
And full disclosure, I'm Canadian, so I'm neither Republican nor Democrat, and I have voted for Liberal and Conservative, and I have thrown away my vote as I did in past election on neither of the two parties that had any chance of growth or election out of principle. So I think, I mean, you guys will tell me what you think. I think this dichotomy between Democrat, Republican, Liberal, Conservative is a false dichotomy in today's day and age, where I mean, any given person has so many beliefs that will be on one end of the dichotomy or the other that it's impossible to place that label with any degree of accuracy.
I was saying this the other day on my stream, I think last night, where I was saying that I consider myself conservative, right-leaning as it relates to judicial philosophy. But that doesn't necessarily mean it applies to any other context, you know? So when you say you're right, left, people assume that means all kinds of things, but how you think about things judicially might not be economically, might not be how it applies in other contexts. So it's a little simplistic to say right or left.
Yeah.
That being said, I tend to consider myself right-leaning. I tend to consider myself Republican. I voted for both parties, but I typically vote more for Republicans. So there's where I stand. But judicial philosophy, I like Justice Scalia quite a lot. So that's where I sit on most things.
Yes. See, I'm a Ginsburg guy. So
yeah. Well, they agreed together on a case we discussed last night. It was Brand X. They were together on Brand X. So Ginsburg and Scalia did agree sometimes.
And they were good friends. They were the best of friends.
Yes, they were.
They were the best of friends.
Yes, they were.
I'm bringing this up because Uncivil Law's commentary on Julian Benton, perfect. Honeybush Vanilla. Okay, that's a curious name, but thank you very much. And I suspect you know what Honeybush is getting at.
I could infer.
Yeah, I will infer.
Okay, while we do this here, let me just make sure that I don't fall behind early. We got Dapper Dave. Did Dershowitz advocate for the elimination of abuse of power and obstruction of Congress clauses because it is so subjective to the party in charge? Dapper, thank you very much. We're going to get into this. Nate, can I disclose the video that you have yet to publish or no?
Of course, yeah,
okay. Of course. So Nate sent me a video this morning that he asked me to look at, and not for my opinion, because my opinion, I'm the one learning in all of this. Like I don't know anything to teach. I'm just learning. I'm trying to form my own opinion. Nate sent me a video where he basically disagreed with Robert Barnes, disagreed with Dershowitz, and gave a relatively compelling video reason as to why. Video's not out yet.
Oh, no, because they demonetize everything I do automatically. So I have to wait 2 days before I can put any videos up that'll be monetized. That's YouTube's policy for me for some reason.
So let me just do this here. I'm going to get to this in a second. So not to spoil the spoiler, but spoiler, Nate disagrees with Robert Barnes and Nate disagrees with Dershowitz. And he's got an argument, and I'm not convinced by Nate's argument, having heard everybody. So the question as to whether or not Dershowitz is trying to eliminate the abuse of power because it's too subjective a criteria, flip-flopping from 20 years ago. I trust everybody is up to date with what's going on and has seen Dershowitz's argument or the summary. Nate, who wants to start with this one? Kurt, you want to start?
Sure. What is the question you want to pose exactly, though?
I guess the question is now, summarize Dershowitz's position or explain Dershowitz's position and why he is now claiming that abuse of power is not an impeachable offense on its own as a standalone. Although I might have just
I have no
answer there for me is Dershowitz is acting in the capacity as a lawyer and therefore is advocating for his client, and therefore whatever his own views are on this question are immaterial. He's putting forward the best cause for his client as a fiduciary, as he should. So if he thinks that's an argument that has some persuasive value, then he should put it forward to this jury regardless of what he thinks. So I don't even view it as an issue of hypocrisy or duplicity necessarily, because what I might believe personally and what I might argue for on the basis of a client are not the same thing. So I just viewed it as putting for the best case possible. I also think, as I said on my live stream yesterday, there's a distinguishment to be made between what the law requires and other issues. So if you say, for example, you can impeach on anything legally, I don't think that's the end of the argument, because you can argue you can't, or at least shouldn't, on political precedent based on what the Senate has done before, their own precedent, based on pragmatic considerations, based on reciprocity, otherwise known as it's going to come back to bite you when you hold this position today. So and philosophical reasons about what the clause was intended to cover. So to the extent he's making what I guess we'd call non-legal arguments in these other veins, I think they're wholly legitimate.
Okay, interesting. And Nate, I know where you stand on this. So you want to dive in?
Well, what I'll do is I'll lay out from my understanding. Dershowitz is laying out three arguments. The first argument is he uses Benjamin Curtis, who's a former Supreme Court justice, and he uses his defense of Andrew Johnson's during his impeachment, that because Benjamin Curtis was successful in his defense of Andrew Johnson's impeachment, that his argument that you can only impeach for crimes is valid, because this Supreme Court justice who left the bench and became the defense attorney for the president made this argument and was successful. That leaves it to be some precedent. Now, I have some issues with that first line of reasoning. Then he goes on to make the abuse of power argument, saying abuse of power is equal to maladministration. And to make that argument, he cites another one of his colleagues, Dr. Professor
Boyd or Boyle?
Bowie, yeah, Professor Bowie.
I don't know how to spell that.
Bowie.
Okay.
And when he makes that argument about Professor Bowie's paper, or first his article, then a paper, he's the only scholar that he cites. But even though he's citing this scholar, the scholar then obviously Professor Bowie says that he does equate abuse of power, because it's a common law crime, not a statutory crime, a common law crime. And he resolves the fact that when they first passed the Constitution, how they didn't have statutory crimes, but most crimes were common law crimes. So that's why when it came to impeachment, Professor Bowie, to be fair, also believes that you should have a crime, but he also includes common law crimes and says abuse of power is a common law crime. But Professor Dershowitz, he says that it's equal to maladministration, and obviously Professor Bowie says that's hogwash and he's misrepresenting the argument. So that was the second piece of the argument, and then the third piece of the argument was the originalist argument and who can interpret what high crimes and misdemeanors are. And then and for that we have Judge Nixon versus the United States with the political question doctrine, and the political question doctrine I think clearly answers the question of who actually decides what impeachment is and what's an impeachable offense. So those were like the three issues that Dershowitz went over that I wanted to address.
I'm totally agreeing with you as to the Judge Nixon case, Nixon v. U.S. I think as to the legal question, what they can legally do, that is pretty solid. It's a political question, and even if it's it's non-judiciable, because there's nothing a court can do about it. What are they going to do? Or the president to be reinstated? That doesn't make sense. So I agree with you.
Well, let's lay it out to what the political question doctrine is, if you can, sure. Just to educate the audience. Go ahead, Kurt.
All right. Well, political question doctrine in the broadest way is that we can split government into politics and law. And we in the United States have split the political into two. So we have a separate executive and a separate legislative, and they're both the political branches. Whereas opposed to in Canada, as far as I understand it, because they have a parliament that elects a prime minister, their executive and legislative can be thought of as united. We have a separated political group. So we have two separate political. And so political questions are those questions that are committed to one of the political branches, either the executive or legislative. They're political, not legal, as opposed to law, which is the legal system, which is the courts. So when we say something's a political question, all we're saying is it's a question that you need to ask a politician about, not us.
But also the courts will not hear cases of political questions. So if you bring up the doctrine of political questions to the court, they're saying we're not going to hear it, and it's not justiciable. That's the key issue. So when and the Nixon case particularly answered the question about who's the sole arbiter of impeachment. So let's say if President Trump was impeached for jaywalking, and he wants to overturn that. If he was to take that to the Supreme Court, they would not hear the case, because the Supreme Court in Nixon said that the sole arbiter of impeachment is the legislature, and the sole people to impeach is the House, and the sole people to judge those impeachments are the Senate.
Okay,
yeah, another example of a political question, just to make this a little bit more concrete, maybe, is if a legislature was debating a tax on something, and someone proposed a 20% tax, and someone else proposed a 30% tax. and they eventually passed a tax at say 28%. It's like, it's politics. You go to a court and say, well, the answer should have been something different. And the court's going to look at you like, what are you talking about? This was something that they voted on and debated on. Any of these answers are lawful. So as to what number it should be, we have no opinion. So that's what political question means, is like, if you think this tax should be one thing or another thing, go talk to the politicians, not the courts.
Okay, and we're gonna get into this in a second, because this is, I think, the key question right now. But let me not fall too far behind quickly. Ross Lloyd, Viva is a loyalist. That's why the Queen is still on his money. I assure you, Ross, I have no say on who is on our money in Canada. Christopher Lambert, future vlog idea. Guy in New York got his student loans discharged in a bankruptcy. So
yeah, that was a good
Leonard
case.
French, I know, just did a video on that, unless I'm mistaken. So
He did.
check that out, because he will undoubtedly have covered it. It's that's a big question, because typically those types of loans survive bankruptcies to prevent the government from getting hosed like regular citizenry in a bankruptcy. Thank you very much for the super chat. Okay, we got this. We got Jim Payne. Could you say hi, Angelique, to my wife? Thank you. Hi, Angelique. Okay. Hi. Hello, Angelique. Sorry, that got weird very quickly. Thank you very much. We got... I'm in trouble. That's it. Now I can't be prime minister anymore.
I doubt that's true, given what we know about prime ministers.
That's as bad as my history gets. What is the legal impact if the vote keeps the president? Will it allow for greater foreign influence in our elections? Peter Mancini. Okay, so we can get to that question a bit, because that question sort of presupposes a bit of the conclusion as well. At least it presupposes the conclusion of fact, which is one of the issues at hand. Okay, I got through the super chat. Now I can relax for a few minutes. Here's the question. Okay, I understand the idea of the non-justiciable questions, which are political questions, which are typically questions how laws should have been legislated. You have and had and will continue to have the Supreme Court interpreting amendments to the Constitution. Correct? Like they interpret the Second Amendment. They're going to interpret what laws. What's the word I'm looking for?
What does the law mean?
Well, no. Does it? What laws? I'm just going to bring that up. What law is in conformity with the Second Amendment? What law is not? So when you have the Constitution, which says high crimes and misdemeanors, and I understand we say it's political questions are non-justiciable. If the question were to ever come to the Supreme Court, what is a high crime and misdemeanor? Interpret it in the same way you interpret the Second Amendment. Well, I have difficulty understanding how the court's going to say we're not interpreting what high crimes and misdemeanors is. It means whatever Congress says. In the same way, we're not interpreting the Second Amendment. It means whatever Congress says it means. And that's where I think that I don't know what I honestly don't know the Nixon judge decision well enough. Mm-hmm. But I would be shocked to understand or fully appreciate that the Nixon decision says we're not interpreting the Constitution, because that's exactly what the judicial branch is meant to do. And if Congress comes in and says high crimes and misdemeanors says whatever we say it means, therefore those words in the Constitution have no meaning, I would imagine the judicial branch would come in and say, no, the words have a meaning, and we're going to make sure your interpretation fits with that meaning.
Well, specifically, the Supreme Court, in the Nixon case, they made two very compelling arguments for political question doctrine. The first argument was if the Supreme, because of the words, they use an originalist textualist argument, saying the words of the act, not the act, the amendment, not the amendment, of the article of the impeachment article, specifically remove the role of the court. It says the sole power of the House has the sole power to impeach. The Senate has the sole power, and it was placed in Article 1, not in Article 3 or a different article where you could make a guess that other branches of government have some influence on it. So the Supreme Court in Nixon says, because of the language, that's the first argument, that it seems like the court doesn't have any role in this. And they went to the contemporary, Constitutional Convention. But then the second argument that was made was that a separation of powers issue. The court isn't supposed to be a super legislature, and the fact that impeachment was a check on the court itself. If now the court can then go and say, well, listen, for instance, you impeach Judge Pinkerton for drunkenness. That's not a high crime and misdemeanor. They said, and this is a very conservative Chief Justice says, that by being able to do that or interpret high crimes and misdemeanors, it effectively eliminates the check that the Constitution granted the legislature over the courts, and by doing so, that's why they can't now interpret high crimes and misdemeanors to be anything, because that was in the sole discretion of the legislature, and it's deemed a political question. Go ahead, Kirk. It seems like you want to jump in.
Yeah, I think the fact that impeachment, the clause exists for all federal officials, because there's only one impeachment clause, regardless of who you're impeaching. And so if we're trying to impeach a member of the Supreme Court, which has happened, then if the court can interpret that, then we have a real problem. Because it's like the Supreme Court can say, oh, we really like this justice, so we're going to say that doesn't count as a high crime, regardless of your impeachment, regardless of your conviction. And so this guy's still a Supreme Court, and now we have a constitutional crisis. So I agree with Nate on the language commitment. And another example of something that is wholly committed to one branch is the power of the pardon, which is wholly committed to the president. The president has the power of pardon. If he issues a pardon, it's valid. End of analysis, right? I mean, assuming the person accepts, because it has to be accepted. But, you know, a court would never review a pardon for, like, did the president have good reasons or corrupt motives? I think even if the president literally took a bribe to issue the pardon is still valid because it's within the power. Now, that might be criminal because of the bribe. It might be impeachable because of the bribe, but the pardon itself is still going to be valid.
But you see,
because of the way the power is structured.
Okay, I'm going to be stubborn, and I'm going to be pig-headed because I'm Canadian, and I'll say I don't understand the Constitution.
That's okay. We can explain it.
Okay, a pardon is not a subjective term that is susceptible of interpretation. A pardon is an act that is done or not done. So the question is never going to be, did he actually pardon him? I would imagine if there were an argument, did he actually pardon him? Let's just say, hypothetically, Trump tweets out a pardon. I don't know if there's any formalities for a pardon, but the guy says, oh, he just pardoned me. And Trump says, oh, and then other people say, no, he didn't pardon him. Trump doesn't talk for whatever reason. Then I suspect that issue would be justiciable. Was that a pardon in the sense of the Constitution? And the court will interpret the act to determine whether or not it was a pardon or not. And if it deems it to be a pardon, unattackable. If it deems it not to be a pardon, not an issue. When it comes to the terms high crimes and misdemeanors, I think I'm going to get stubborn and say I will never accept any idea that says it means whatever Congress wants it to mean, because then if it did, there was no point putting those words in the Constitution in the first place. You could have just said they can impeach for whatever reason they want, but they put in the words high crimes and misdemeanors to have a meaning and not one that would be undefined and susceptible of whatever the whim of Congress was.
You know, it's
tell me I'm wrong.
No, it's funny because usually when this was even presented, a lot of people have a hard grasp of this political question doctrine, because you're right. There are words there. High crimes and misdemeanors mean something. It does mean something. But like my constitutional law professor said, you know what it means? It means exactly what those who are allowed to interpret it means. Because even, I don't know if you guys, well, I'm assuming you guys have mistake of law too, where you have the one guy, he reads the law book, he'll say it means this. Like we have a big case here in New York where he wasn't a cop, he was a corrections officer, he's a federal corrections officer. And the law in New York said, well, if you're a corrections officer, you can carry a firearm on and off duty. But that law was interpreted by the court system to only mean state corrections officers, even though the law itself just said corrections officers. There was a judge and there was a ruling back, like 20 years ago where the high court in the state said that only meant state corrections officers. So this guy was a federal corrections officer. He went to the gun shop. They read the statute. He went to the cops. They read the statute, and he carried a gun and was arrested and charged with that particular crime. And and it was called mistake of law. And the court, in that case, the court said even though he's right, a plain reading of it means something, but he does not qualify to interpret the law. It is the courts who have that authority. But in this situation, when it comes to impeachments, it's not the courts. Unfortunately, it's Congress, because it's a political question. Just like how we accept the courts have that role to tell us what the law means, even though it may say something different. In this particular instance, the courts have said, the courts, and not a unanimous Supreme Court has said it's Congress who tells us what that means.
I'm going to have to read that particular Nixon decision because I refuse to accept the conclusion. And it's not political bias because there's no policy in it. It's just, It doesn't make sense. There are words there. They have to be interpreted and not disregarded.
But then it becomes the question, interpreted by whom? And that's the operative question. Who gets to make this call as to the language was Nate's point. And if you say, well, the House has the sole power to impeach, which it does, and the Senate has the sole power to try, which it does, then sole suggests sole. And to the extent that they're making a mistake, they are the court of last resort. They're sitting as a court. This came up in Clinton's impeachment trial, where someone called them members of the jury and someone objected and said they're not jurors, and the rank West at the time said they're not jurors. You are the court. You are sitting as a court, and don't refer to them as jurors. So it's like, who gets to make this decision? And the Supreme Court normally interprets the Constitution, but if their interpretation of the Constitution is that sole means sole and it's wholly committed to the legislative, then I think that's fair. And the idea that some judicial power should exist in the legislature, to the extent this is judicial at all, is not wholly belied, because the pardon power is often considered judicial power, which belongs to the executive. So some judicial power might not vest necessarily in the judiciary, but that's the way the Constitution sets it up. So I'm forced to agree with Nate and disagree with you, Viva.
It doesn't matter. I'm stubborn. I'm going to stick with
Okay.
There's no other explanation that makes sense. But hold on.
Barnes got you, huh?
Logic has got me. Words have meanings or they don't. But hold on. Okay. Al Dente says, is it possible that Schiff can be charged with sedition for the circus?
No.
George Orwell, 1984. Very nice avatar. I'll predict the answer from the two American lawyers. No, because they're acting in their capacity as politicians. But
also, I don't believe sedition is a federal law at this point. There was the Alien and Sedition Act way back when, but I don't think sedition is on the books right now. So there's that.
We got, by the way, thank you very much for the super chat. Dude X01, have you seen the SNL skit on Alan Dershowitz? Can't click it right now. To attack him. Was it fair to attack him on his former clients?
Yeah, premise of the skit is Alan Dershowitz goes to hell and all his former clients are there. And the guy who also made Baby Shark is there, because why not? And so they're attacking him on his evilness for his past representations. And I default to what I said earlier. A lawyer is not his client. A lawyer represents his client and puts forward the best case for his client. And if Alan Dershowitz is the best lawyer, let's assume, then it makes sense that people who are the most hosed would want him. And so he'd have a lot of difficult cases. But if he's good in presenting legal arguments and representing his clients, that's kind of what he's supposed to be doing, unless you want to argue that certain people shouldn't have representation or should have less than optimal representation.
Sorry, don't get me wrong. No, I just want to say Alan Dershowitz, even though I disagree with him with this, if I was in trouble and you can give me Alan Dershowitz, that's who I want. You know what I'm saying? Just because we disagree with him doesn't have any stature on the type of attorney that he's a fabulous, probably one of the best attorneys in the country. So, but again, I just disagree with him with this particular point.
And I'll just highlight something I've mentioned in previous vlogs. And I know I take a lot, I poop a lot on lawyers because they're annoying people, to put it very, very mildly. But there's a difference between representing, call it a bad client for lack of a better word, or a guilty client. And there's a difference between representing a client in a bad manner or in a guilty manner. And you can represent a client who may be guilty on totally legitimate means. And it's different than representing even an innocent client using illegitimate means. And people like to shit on I'm done. People like to poop on lawyers, and they like to call them names. And they like to get mad at them for using technicalities to get their guilty clients off. But they are, to some extent, ensuring the due process that should be applied to everyone, guilty and innocent alike. Because if you let improper process affect and condemn a guilty person, it's only a matter of time before it comes down on an innocent person. And that's the biggest distinction. It's like, I don't know who Alan Dershowitz defended except for one big name who he might have, I don't know what his relationship was, but
O.J. Simpson?
No, we'll forget O.J. Simpson. One thing's for certain, whatever came out of O.J. Simpson's acquittal, they put in protocol to ensure that the mistakes that happened will never happen again.
Yes.
And no comment on the rest of it. But no, I mean, look, a lawyer can defend a guilty person on legitimate bases, or they can defend a guilty person on illegitimate bases. And that's where it becomes a question of the morality of the lawyer. I don't know Dershowitz's morality in general, but I don't think it's fair to attack a lawyer based on who they represent, but rather based on how they represent those people. So that's the consensus among the lawyers in the chat. Now, I think I saw something that I might, if I miss anybody's super chat, please tell me because I won't sleep well if I don't get to them. I saw this one. Let me just see here. Oh, okay. We got a substantive one. What about Joe Arpaio?
Yeah, all right.
Okay. If I skipped one in the meantime, I don't think I did, but we got that one, and I saw another orange one. What about Joe Arpaio? Trump pardoned him before his due process had been exhausted. Did the pardon violate his due process?
No, not at all.
Not at all.
Not.
You don't even have to be charged to be pardoned.
Yeah, you can be pardoned for future crimes, right?
I mean, you have to accept the pardon, which also means that there's not a due process violation. They can't force a pardon on you, which actually came up incidentally in Obama's clemencies. There was a guy that Obama he clemencized whatever a whole bunch of people right at the end of his term for drug related crimes, and there was one person who actually refused the clemency because he thought he was better off without it. So he served an extra year in jail because he thought he was better off without the clemency. So you can't force it on him. So it's not a due process violation.
Nate, but did someone just say that you can pardon someone for a future crime, as in one that they haven't yet to be found guilty of, or not one that they have yet to commit?
Oh, I think you have to commit it first.
Yes,
yeah.
Crime
has to be committed, but you don't have to be charged to be pardoned.
I was just joking.
Okay, no,
it was a poorly timed joke, but I did say because I was making a joke about pre-crime, but it's okay.
I'm not trying to hold it out and take it out of context for a political ad. What I mean to say is, you don't need to be found guilty of the crime in order to have the condemnation of guilt pardoned. You can be pardoned on an anticipated potential condemnation of guilt, even though you haven't even stood trial yet.
Well, the way I understand, there has to be some process that has started. Like, maybe they have to indict you or bring formal charges side. Like you can't just indict
because Ford pardoned Nixon, and nothing had started with respect to Nixon at the time Ford pardoned Nixon. Remember, Ford gave a blanket pardon.
Except for potentially the articles of impeachment that had begun being drafted but were not yet approved.
Well, you can't pardon.
This was after he had already resigned from office.
Yeah, because you can't pardon.
He gave him a pardon for any crimes he might have committed. He hadn't been charged or arrested or even indicted or anything.
Yeah, that's
that
true.
pardon was valid.
But hold on, Nate. You can't pardon impeachment now that you.
Yeah, you can't pardon yourself out of impeachment. That's right.
We got Peter Mancini. If anybody doesn't remember Princess Bride, Mancini. A high crime is one that can be done only by someone in a unique position of authority, which is political in character, who does things to circumvent justice. And so that would be an interpretation of the term high crime and misdemeanor, which I tend to agree with this, having heard Robert Barnes and Alan Dershowitz. But Nate is as thoroughly convinced in his position as I am now and convinced in Robert Barnes's position. Thank you very much for the super chat. But Nate.
Can I just want to add one layer to that. I think we both can be right. For instance, I think the contextualist argument that this is what it meant back in 1800s, and this is what it should have meant, and that type of thing. I think that's correct. I think high crimes, that means something. But I think you can also be right in understanding that today, and the way the law is today, and the fact that the Supreme Court has deemed this to be a political question, means that who decides what it actually means today is the House of Representatives, and that can be anything. So I think both can be right. It's not either or.
Okay, and we got Dominic M saying the law is subject to interpretation of the authority having jurisdiction. Not knowing what Dominic is quoting, do you guys know what he's quoting?
I think he's right.
Yeah, it's defining jurisdiction. More
okay, but now, so then if we move on that, then the law, we would agree that the Constitution is the law.
Yes.
Okay. The Constitution says something.
Mm-hmm.
The United States government has three branches: the legislative, executive, judicial. Mm-hmm. The law says something. The only people or the only branch empowered to interpret what the Constitution says, is the judicial.
Mm-hmm.
The judicial.
That's where I break.
Okay,
I think, as I was saying, there might be judicial power in other branches, and to the extent you view this as judicial, I think this fraction of it is in the legislature.
But I think Viva's talking about generally judicial review, generally. But I know what you're talking about. But generally judicial review, yeah.
Yeah.
So in other words, he's just caveating it. Not for instance, regulations are interpreted by the agencies, not even by the courts. So there are some laws that just aren't interpreted by the courts. But generally, judicial review, yes, Viva's right.
Yeah, but I'm only bringing it back to one law, which is the article of the Constitution that says someone can be impeached for high crimes and misdemeanors. Who interprets that? And now the position is, for whatever the reason, judicial gets to interpret the law in general, but does not get to interpret the law as relates to the definition of high crimes and misdemeanors.
But they have, but they have though. The thing is that you're right. The judicial branch tells you what the Constitution says, and they said, okay, when it comes to high crimes and misdemeanors, we're going to tell you what it says. You know what? Ask those guys, because those guys are the ones empowered to tell you what it actually means. That's what the Supreme Court says. We can't tell it to you because those guys are the ones that can tell it to you.
And that is Nixon, not President Nixon, but Justice Nixon versus the United States.
Yes, and look at Judge Nixon, and even look at the Nixon case. Judge Nixon was impeached for a crime. The impeachment wasn't the problem. When he got impeached, instead of the Senate holding a trial, because it says, Senate shall trial impeachments. So they didn't hold the trial. The impeachment went to a committee, and the committee said, you know what? These things are so bad, Judge Nixon needs to be gone. So it went from that committee straight to a vote on the impeachment, and the senators voted him out. So Judge Nixon went and said, hold on. The law says try. They get to try impeachments. I didn't have a trial. They didn't try anything. I went to a committee and they voted and kicked me out. That's what the Supreme Court said. We know what it says, but we can't interpret it. You know who interprets it? The Senate interprets what that means because they have the sole power. And the House interprets what they can impeach for because they have the sole power. So even though it says you get a trial, guess what? Yeah. You don't get a trial.
It's also clear that the Senate is the master of its own rules. So They get to define what trial looks like to them. If they want to give the power to a committee, okay.
See, but I swear to you, I'm going to have to go do like an analysis of that.
Go read the case and then
what it sounds like here. What it sounds like here is that what was at issue was the trial aspect and not the meaning of high crimes and misdemeanor aspect.
I did want to read this one super chat from Jem Jeffries before it went off the screen.
Which one?
Don't stop the conversation for this. I'm just supporting the argument. Oh, why not? What did the Americans think of the vlog dog? Well, I'll tell you what. I really like Viva Frei. I watch him all the time, and I mean this genuinely. I'm actually a fan. I think he produces really great content, and he inspires me. He's a better editor than I am. I think he's a better storyteller on the whole than I am, but he's been at it a lot longer than me, too. Because you've been vlogging for multiple years, so 2
years of daily vlogs can teach.
Yeah, I think he has a brain in his head and is informing you with a well-informed, educated opinion. The same reason I like Nate. We don't have to agree on everything all the time because he has something valuable to say, and I want to learn too. So Viva's great.
Thank you very much. I'm going to get to that super chat. Crispy leg is what it says. What did the high crime and misdemeanor mean 1776? Yeah. Okay. Who wants to start? First of all, thank you very much for the super chat, and I'm going to go to the next one. But who wants to field that one? Because that's
me. I'm not even sure. It's like I'm not. Well, you know what? It's funny because if you look at all the different commentary, some people say high crimes meant high crimes against the state. Some people say high crimes mean something else. So if I would just go with Dershowitz's opinion, is that it meant whatever he says it meant. But I think in the relevant context of the conversation, it's irrelevant because the Supreme Court, I think, has already ruled about the political question aspect of it.
All right, and here we go. Jeff Jeffers. Now we got to the super chat. Thank you very much, Jeff. But then the funny thing is listening to what Dershowitz said on the interpretation, which was high crimes and misdemeanors, and because he addressed the argument that the I call it the Dems, but it's not a question of politicizing, but the Democrats were saying there were no laws, and that's what one of the arguments was. There were no codified laws to begin with, so it would make no sense to refer to codified laws because this was before laws were codified. So high crimes and misdemeanors sort of could not have meant only that which was already a crime. And Dershowitz's response, which is what I sort of addressed in my analysis or summary of his breakdown, was that they said bribery and treason, which were not yet laws, but they knew were going to be laws because they were going to pass them as criminal laws. And so the idea was that it was going to be bribery, treason, not yet laws in the technical sense because they hadn't passed it, but would be, and other high crimes and misdemeanors in the same vein as what was going to be passed in terms of bribery and treason. And it's not stubborn doggedness. I mean, it just makes sense, because if it were to mean whatever else Congress meant it to mean, that's what they would have said, and not specifically phrased it so that it was going to mean that which they were about to pass as criminal law before they passed it.
But Viva, they had laws, they had criminal laws.
Well, so they had common law, right? That's the argument.
Yeah, and that was the laws that most people were talking about. Just like they have common laws for contracts, they had the same thing for criminal laws until they codified them. So I think in Florida, didn't they codify all of common law? And their first I think it was in Florida, one state where they had no laws. They codified all common law at one point. So so there was laws. The bribery was against the law, but it was just a common law offense. Well,
and now, okay. First, I'm going to thank BB. Thank you very much. The red is a very striking color, but thank you very much for the super chat. And I had right above him, I agree with Viva Frei's analysis. Is irrational. You're agreeing with the least educated in the field of the law that has had issues. So bear that in mind. But BB, thank you very much for the super chat. I understand. I appreciate those arguments. And it's just a question of okay, but it was, from what I understand, it was never intended to apply to common law as a rule, because they didn't want to bring over that from which they were just escaping, and they were they were building their own foundations. And yeah,
no, hold on. What do you mean? All of the whole law from before we had Congress, we assumed all of common law, all English common law. We still even teach English common law in law schools today. The United States government, our whole legal system is built off of English common law. So it wasn't like they said we're not going to do all that stuff. It was these guys have something working. We're going to use that until we can codify our own laws.
Okay, no, but true. But now, when it comes specifically to the impeachment, where they say bribery and treason, which was bribery? I'm asking a question now. Was bribery and treason a common law crime?
Yes, they were common law crimes.
Okay, so
I
now
can also do you one better on treason, because it's actually defined in the Constitution. So you don't need a statute, because it's actually in the Constitution defined. So there's that.
Okay, very well. That's only building the argument that the bribery, treason, defined in the Constitution, and other high crimes and misdemeanors.
Bribery's not.
Well, bribery's not. So now,
bribery was always a common law crime, though.
I guess the bottom line is you get the fundamental question is, what was because you're trying to read the spirits of the founding fathers, and I love. First of all, I love that term, the founding fathers or the founders or whatever. It's almost biblical in a sense, which makes me like it. Whatever.
We romanticize this to death, and I'm all for it.
Yeah, well, it's great, but so you're trying to what's the word? What is the word? Not a Ouija board, when you try to get the spirit of somebody. You're trying to pull the spirit of the founding fathers. Yeah. Well, there's a word. There's a specific word. Someone's going to get it. Say it again.
Seance?
No. It's when you're trying to reach their spirits and their souls. I forget what it is. Tom Rader, thank you very much. No, oh, come on. And there's whatever. You're trying to connect with them spiritually. You're trying to say, what were they trying to do? And the question is this: what were they trying to do? Were they trying to empower Congress with the power to remove a duly elected president on their capricious desires of the time, or were they, which sold me on this, which brings you back to a parliamentary democracy, or were they trying to make it the most serious form of removal of duly elected official, and not leave it in the purely discretionary interpretations of Congress? And if you ask that question, I don't know how you could disagree with it.
Well, let's look at it maybe a slightly different way. Suppose you had a provision in the Constitution we would agree is to be interpreted by the judiciary, and you're before the U.S. Supreme Court, and you're arguing this provision clearly means this or whatever, and the court comes out with a decision and says, no, it means this other thing completely. So, suppose the Supreme Court were interpreting high crimes and misdemeanors, for example, for a moment. And you say, it has this particular meaning, and the Supreme Court renders a decision and says, well, we think it means X, Y, and Z, which may or may not comport with what you argued, right? But you'd recognize that decision as final, even if you thought that it was the wrong interpretation. The Supreme Court, got it completely wrong. So in the same way, if you're arguing to the court that is the Senate, and you're saying the law should be understood to be this. By high crimes and misdemeanors, this is what the founders clearly had in mind. This is clearly the scope of what it has. And the Senate says, nope, 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 nope. We define it to mean this. Then why is it any less valid for the Senate to be the final arbiter and get it wrong versus the Supreme Court to be the final arbiter and get it wrong?
And
I mean, someone has to be final, right or wrong, right?
And this is going to be my ignorant, but maybe like virgin perspective of it, because that's the role of the judicial branch versus the role of the executive and the legislative. Now, admittedly, the legislative did not. Well, actually, I don't know who drafted the Constitution. It wouldn't technically be the legislative. It would be.
Sure, it was. Like, it was the Continental Congress.
It's like the government establishing its own rules before they're to make them. So who would interpret it? Yeah, based on the separation of powers, I would say it's the judicial who gets to interpret it, not the legislative.
But let's not forget too, the power of interpreting the Constitution was not given, like that was taken by the judicial branch. It wasn't given to them. Like the Constitution doesn't give them that authority. They gave themselves that authority in Marbury v. Madison.
Yeah, that was a big coup. Yeah, they gave themselves the judicial review big time.
Yeah, it was a big scandal. Even reviewing state, because remember they didn't at first judicial review just was with federal stuff. Then they had to give themselves the power to review state stuff against the Constitution. So the judicial review and interpretation of laws is all a big grab by the Supreme Court to get that power that is not within the Constitution. So if we are talking about being strict constitutionalists, then we're talking about throwing out judicial review, because that's a power grab by the Supreme Court in a case called Marbury v. Madison.
Okay, we got two separate decisions for future vlogs without a doubt now. Sam Antley says, not a lawyer, but it seems that an originalist interpretation is okay for most every area of the constitutional law, but this one.
No, you got whole doctrines out there of like substantive due process. The whole doctrine of substantive due process, to not even.
I don't think from my perspective, what I'm arguing is a non-originalist argument, because the question is not only what does the phrase mean, but who gets the power to decide ultimately. So you could make the originalist argument like, I don't know, freedom of speech means X, and on the same token say the Supreme Court originalist, or in view of Marbury versus Madison, has interpreted to mean this other thing, and now that's the law. So I don't think it's non-originalist if you say, or you accept the premise that the Senate is the court to judge and the court of last resort, that it might mean something, but they're the ones interpreting it. So I don't view that as non-originalist personally.
Yeah, that's a good point. But the funny thing is, like I say, like, okay, I can agree that the Senate, first of all, Triad has had two $1 super chats, and thank you very much. I want to get to them.
Triad.
I can appreciate that the Senate has the sole power to try. But then to try what? And then we'd have the word. And then the question is, well, if there's a disagreement on what the word means based on how it's drafted in the law, I would say the judicial comes in and then defines the word for the trial, for the Senate to have the trial on. But it sounds like, and I'm going to have to read it thoroughly now. Nixon says we don't interpret not just the trial, but we don't interpret that on which the trial is being held.
Yeah, but yeah, because see, the thing is that, and I think this goes back into the process because it's a twofold process. The accusatory process of impeachment, the House is just accusing the president of something, and the Senate is the judge of that impeachment. So you're right. Technically, if the Senate says this is a BS impeachment, we're going to acquit, that's their right, but they're judging the work of the House in that sense. One is accusing and one is judging, and that's that. In other words, answers the question on if they just impeach for BS, that's the Senate's job to judge it as BS, like they're doing now with this current impeachment.
Okay, now, and instantly, perfect timing for this, because Chad Houston, impeachment was meant to be the yeet seat. Don't know what that means. It's the big red button. It's meant to be used when the vote is so corrupted or the offense is so bad there is no other remedy short of bloodshed. Now, this
you got to work on your slang there, Viva, if you don't know yeet.
Say it again.
Yeah, so you got to work on your slang if you don't know yeet.
I'm gonna Google it so that I know it. But so this argument I understand, where it's so corrupt that if we don't remove him, there's going to be an uproar. Flip side, remove him for jaywalking because the Senate and Congress, because the House and the Senate don't like him. There's going to be bloodshed also. Like one way or another, if there's no temperance of this big red button, there's going to be revolt one way or the other. And not to apply it too literally to the current impeachments. You have enough people thinking if they impeach Trump over this, which what many people believe to be what was never intended to be a basis of impeachment under the Constitution, people will take to the streets.
Well, and that is the court of appeal, as it were, for the Senate. So there is one step of review, which is the fact that they have to be reelected, right? So exactly, there is a remedy, political remedy on a political process. So yeah, you appeal to the American people, they elect different senators, put in place different laws, blah blah blah, etc. So yes, the House and Senate can do whatever they want, and yes, the people can then throw them all out of office. So,
even think about this, Judge, what's his name? The Chief Justice, when Roberts, when he was talking about why he wasn't going to vote in the 50-50 tie, right? He was like, if it's 50-50 tie, motion's defeated, that's the way it's good. And they were trying to say, why wouldn't you vote? And he said, because he's an unelected and he's from the judicial branch, and their votes, the senators' votes, has a political process that has to deal with, and they have to be accountable to the voters, where the Chief Justice doesn't have to be accountable to the voters. He's got his job for life. So that's why he would not cast a vote, because an unelected judge is not beholden to the political process. And since impeachment is a wholly political process in question, then he would not even cast the deciding vote, because he is an unelected judge.
Mark the minute down. It's 56 minutes and 10 seconds, and this is my revelation. Okay. The impeachment is necessary when, in the opinion of the Congress or Senate, when the conduct is so bad, they have to be removed. And the only check and balance then is the vote of the people who are going to vote back in the Senate, who have just effectively voted out the person that the people have voted into power in the first place. Nobody sees the paradox here. That's great.
Power checking power.
Well, it's power checking power, but it's ultimately now the Senate is saying we're going to act in such a way to overthrow the will of the people, and if we do it in a way that the people don't like, then they will overthrow us by voting us out because we voted out the person that they voted in the first place.
Right.
Yeah. That's the system we live in.
Which in the name of survival would prevent them from voting that way in the first place. So yay.
And think about this though, because you keep asking the question, who does like just a couple of people are saying how it has to be this high bar, how it has to be this, impeachment's a last resort. Well, who decides when it's time to press the button? Who decides when it's time to press? Who decides when that act has become the time to press the button? Is it the courts? No. The sole powers in the House of Representatives. So they get to determine when it's time to press the button.
Okay, well, that's very interesting.
You hate the fact that they get to decide. Hey, he jaywalked.
I am digesting. He jaywalked, and we don't like him. Let's vote him out. The people voted him in. If we vote him out in a manner that's abusive, then the people will vote us out for having voted him out because they voted for him and they want him, and we did something wrong. Yeah, okay. I'm still not convinced just based on the interpreting the language as used, but I appreciate that dynamic. I just also think in the actual reality of, I don't know, only in today's day and age, the idea that you would be able to vote out the people who voted out the person that the people voted for, you're so far removed that the process is going to get corrupted in the meantime, where it's actually never going to be the reflection of the will of the people. But
well, hold on. You don't think those Republican senators in those ruby red states who are up for re-election right now in Trump country, if they vote against Trump, you think they won't have any political problems?
Well, they will. They will. I mean, I think anybody is going to have political problems regardless of the way they voted, setting aside exceptional circumstances where they're not based on their jurisdiction or the demographic.
Yeah.
But we're talking about Republican senators and Republican states that love Trump. And if they vote to convict Trump, there's going to be a political price to pay. And it's likely going to be their job.
I don't know what the Democrat senators really believe in their heart of hearts, but assuming like one of the senators from California really thinks that it shouldn't be, they're still going to vote for it because the political ramifications.
Chuck Schumer's voting for impeachment.
Political penalties.
Just imagine Chuck Schumer voting for not to convict.
Yeah,
he would have political price to pay.
Maybe he really in his heart thinks, but I don't see that going well.
It's fair enough. It's very interesting. I'm absorbing it. I'm not necessarily being convinced yet, but I'm absorbing it. Carl says if they want enough support to actually gain the 2/3 votes needed, they need a crime proven beyond a reasonable doubt. I mean, I guess that satisfies the basic element of it, but it doesn't. That might satisfy it in fact, but not in law. In law, it doesn't resolve the ambiguity. If it's not an actual crime, can it serve as a basis for an impeachment? Okay, well, that's very cool.
You know, lest we put too fine a point on it, the House never has to impeach. So up to and including the House having proof positive the president actually committed treason, the House isn't obligated to do anything about it either. So there's that.
I missed one. I know that I missed one super chat. Mandatory Carry says, at work, can't stay and play, but keep fighting and self-reflecting. Mandatory Carry has one of the characters from Star Trek on as his avatar. So if I missed it, I believe I missed it because I see it here, but I'm
mandatory. I got it.
Thank you very much. And then we got Mr. Frankenstein, M. Franklinstein. Okay. This will hurt the Dems next time they win presidency. They always do stupid stuff. Reps warn you want to set this precedent, then use that precedent to smash Dems in the face when reps gain that power. Yeah.
I was saying this on my channel. I saw Nate's video of this recently where he was playing both Ken Starr and Alan Dershowitz videos from the previous time, and then reviewed the Democrats what they were saying last time. It's like, we just flipped. We just apparently took our scripts and handed it to the other side, and they're saying exactly the same things. But that is like another check also on the impeachment process too. It's like, yes, you could theoretically impeach for anything, but if you do, there's a reciprocity element to this, because next time will be 4 years from now, probably, the way things are going these days. But next time, it will be your guy, and we'll be making the arguments you were making, and you'll be making the arguments we're making. So in the idea of consistency, maybe we should try to think ahead.
Yeah, well, you try to think ahead, except nobody can think past the next election day or the next news cycle. There, I found Mandatory Carry's super chat. Thank you very much, Mandatory. Yeah, but then the reciprocity turns into, you want to talk about lawyers who spin things like, oh, well, don't do what we did the last time because now you're just being vengeful and like deal with it on the merits of this time around. Yeah, then it becomes a question of who's going to pull the higher ground and not pull the same dirty stuff that was pulled the previous time around, but nobody remembers the good deeds. They just remember the dirty play. That's what litigation is. It's no favors in litigation. Joe Ward says the Constitution didn't count on TDS, which I know what TDS means. Still don't know what yeet means. It means, according to the Urban Dictionary, a form of excitement. But
throw away.
TDS. Okay, we're at it. Thank you very much, Joe, for the super chat. Okay.
One thing I do want to say before we move on from this is that Alan Dershowitz, I was watching his argument earlier today that he made on the floor of the Senate, and he cited Benjamin Curtis, who was the dissenting opinion in Dred Scott, the horrible Supreme Court case. So they can be wrong, but he cites him like he's citing a Supreme Court case. Judge, Benjamin Curtis says this. And he's not citing a Supreme Court case. He's citing a lawyer arguing for his client during a trial. That's not legal precedent. You know what I mean? And I'm trying to understand why that seems convincing when Judge Curtis was the defense attorney in Andrew Johnson's impeachment. And even in the case that we're talking about, Andrew Johnson was like, his 10th article of impeachment was for bad-mouthing Congress, which was obviously not a crime. Now, Judge Curtis he's articulate and he won, but Alan Dershowitz has more or less said because he was successful in getting Andrew Johnson off or him not being convicted, we should then also believe that his argument was convincing and use it as precedent, the fact that you need a crime to impeach. But that's just like saying Bill Clinton's attorneys should now be used as precedent because they got him off for perjury and obstruction of justice. So now are those no longer impeachable offenses? Well,
and that was where I wanted to go. The next point, that was one of the other elements that thoroughly convinced me, both from Barnes and Dershowitz, is that in Clinton's case, everyone's citing it as a question that it didn't need a crime, it didn't need an actual crime, but there was an actual crime. And in Clinton's case, it was that the argument was being made that the crime was not sufficiently high enough to warrant impeachment. So it is a crime. We agree. doesn't satisfy as a high enough high crime under the high crimes and misdemeanors. So we accept that it can be a crime, but it has to be a serious enough crime to warrant impeachment. So not just whatever Congress wants, because, I mean, in theory, then, I mean, this is the other thing. Actually, now I'm speaking out loud. It could be, let's just say that it can be whatever Congress wants. So let's say Congress wants to not impeach on sedition or murder or treason. Why can they not get away with not impeaching on the most highest of high crimes? And who would accept that as a logical conclusion? Checkmate. I'm joking.
I think I said that earlier, that up to and including treason, that they don't have to impeach. But the fact they don't have to, the political ramifications, of course, are another factor. So I would imagine they're going to have a tough time with their constituency if they chose not to. So,
unless everyone just hated the person enough to set aside the actual law, which would not be an application of the law, it would be a disregard of it.
Well, I think it's setting aside the law, because this is not really. Oh, geez, because I run out of language, because it's like, this is not really legal, but then people will understand. So is illegal? Legal? I'm trying to make a point, and I run out of language at this point. But all the impeachment can result in is being thrown out of office and being disqualified. And incidentally, while I'm thinking about it, because I think someone asked in a super chat, but if they impeach, can Trump run again? Depends. Yeah. They need a 2/3 vote to throw him out of office, and if they do that, then they only need a majority vote to disqualify him. So hypothetically, they could throw him out of office and not disqualify him. So the answer is it depends. But yeah, you can be guilty of the crime of treason, and when you're out of office, be charged with treason by the U.S. attorney. But the impeachment is a political process with only political consequences. So you're not really setting aside the rule of law or setting aside the law. You're doing something that's politically expedient versus legally expedient.
Well,
because only penalties that are possible are political penalties.
Well, can I give you a real life example of the impeachment of Bill Clinton? Bill Clinton was actually going to be charged with a crime after he left office. Most people don't realize what had happened. He negotiated while he was leaving office with the Justice Department because he had committed 2 crimes, obstruction of justice and perjury. So part of his settlement agreement was he actually came to a settlement agreement with the Justice Department before he left office, so he wouldn't be charged with federal crimes. And on top of that, he was disbarred in both Arkansas and on the federal circuit. So just because he was impeached didn't free him from all the liabilities of him actually committing those crimes. So he did suffer the price.
That's very interesting. And that was where was that part of the $800,000 settlement, and the disbarment was as a result of those crimes?
Yes, the disbarment from the federal circuit and from Arkansas were all about the perjury and all that other stuff, and him negotiating with the FBI before he left office was because he had committed perjury. So all that, yes, they wrapped it all up together.
That's phenomenally interesting. I was so young and naive at the time. I'm reassessing my own memories of history in light of what I'm now learning, and it's phenomenal. We got B Turn, who says impeachment removal is also a check on judicial. If they can define high crimes, they can undermine the House Senate's check.
He should have just watched the first part of the stream when we mentioned that. It's exactly what we mentioned early on. But that's the argument in Nixon.
Supreme Court justice, if the Supreme Court gets to interpret it, then you have a real problem.
And
especially if the Supreme Court members like him.
And this is William,
because whatever.
William Rehnquist, the Chief Justice of the Supreme Court. That's exactly what he said in Nixon.
Yeah.
If we do that, then we have all the power.
Okay.
By the way, because I saw it come up in chat a little bit about how many years Trump could theoretically serve. I think it's the 25th Amendment, but regardless, no one can serve more than 10 years as president, period. So all you people who are talking about 12 or whatever terms, no, it's not happening. Trump and everyone else is limited to 10. And the only way it would come up is if a VP was, serving part of someone else's term, then they could run for re-election twice. So,
but the VP can serve forever.
It's not happening.
No, VPs can serve forever, though. Remember, VPs can serve forever. There's no term limit on VP. They can serve forever.
In their capacity as VP.
Yeah,
they
have no term limits for VP.
You might be right.
Okay, so now someone says, you stumbled on why the 17th Amendment must be repealed. It violated the guarantee clause.
Well, a constitutional amendment can't violate any clause of the Constitution because it's a constitutional amendment. Total argument is a complete non-starter.
What's
That's
the 17th
the point of
Amendment?
amendments?
What's the 17th?
It's the one that lets Senate be elected by people as opposed to the states appointing them. So it's direct election of senators.
Okay, interesting.
It's
so
like
even if it does violate the guarantee clause, literally no one cares because it's an amendment.
No, it's funny. Hold on. This is also funny too. You know, the Constitution violated the law too, because the Articles of Confederation, the only way you can amend them was by a unanimous vote, and they didn't have a unanimous vote. So the Constitution itself is an illegal document. So.
Yeah, we're looking past that, I guess.
Yeah, we'll just forget about that.
This is slightly over my head now. Actually,
I'm sorry. We should explain.
What is the guarantee clause?
Oh, there's a clause in the Constitution that says effectively the American government, federal government, must guarantee to every state a Republican form of government. And there was a case, I think it was heard by the Supreme Court out of Rhode Island in like the 18th century, which basically says, yeah, we can't figure out what that means, so don't ever ask us again.
Okay, well, God, I'm just like keeping a mental checklist of videos for the future. I'm gonna know American law and history better than Canadian. Well, I say government better than Canadian government. Matthew Chris, thank you for the super chat. Yeah, I tell you, I'm gonna know more about American government functions than the Canadian. It's crazy. Okay, so we got a bunch of articles exchange. So we did the Bill Clinton argument. I think we did a bulk of the impeachment. Is there any question that anybody has about the impeachment that we have not yet answered?
You know what? One thing I do want to mention that I think I found so crazy about today is that looking through Alan Dershowitz's arguments, he mentions. Hold on, I wrote it down because it was so crazy. He mentioned Senator James W. Grimes, and he mentioned him because Senator Grimes, you know, after the impeachment of Andrew, he was one of the senators, the Republican senators who voted against impeaching Andrew Johnson, right? One of the people who saved his presidency. So he quotes him and says, you know, even the great Senator Grimes says impeachment, you know, you have to have a crime to impeachment. But he failed to do research on Grimes because Grimes was thought to have been bribed. 6 of the senators, Republican senators, they thought had been bribed to vote for Andrew Johnson. And an investigation showed that it was likely that they were actually bribed with gifts of, you know, after they leave office to actually, you know, to vote this way. So it's wild because I'm surprised he would actually go to this senator and quote him, knowing that this senator's vote is likely gotten through bribery. You know, so I don't know. It's crazy. But again, it's probably me because I'm going through this stuff like a maniac. So
it is it is amazing. It's amazing. First of all, it's amazing that if this impeachment has done nothing good for the country, it has educated a great many people about things that they had no knowledge of beforehand. They just have to make sure they get like the proper understanding of what's going on. Viva Frei, is it that someone can hold office of the president twice or 2 consecutive terms? Okay, so get to this question because I know people have been asking it, that if a president is impeached and then acquitted, they can serve a 3rd term. I've heard that argument and I've heard that discussion. No. Okay.
No, the 25th Amendment is the limit on this at 10 years. That's not happening.
So how can it be? How would it occur then that a president that's 4-year terms, 2.5 terms? How would it ever occur?
The vice president,
that a VP took over from the president's term,
half term, yeah.
So he served a half term or less, then he can run for 2 other terms.
And so, to oversimplify to the point of clarity for everybody, a president, even if impeached and acquitted, can never serve more than 2 terms.
Yeah,
correct.
Okay, so that urban legend, the rumor that I've seen it being raised, like if you know the meme is if you want to trigger people, tell them that if Trump gets acquitted, he can serve a 3rd term.
No,
absolute hogwash, according to the 2 of you, and I defer to you
for the first time. But thank you.
it might. Well, I may have deferred to you previously, but you wouldn't know it. But I openly defer to you on this one. Okay, Sarnex Zero. Is it treason if impeachment is done on false pretenses? If Schiff colluded with the whistleblower before the report, for example. Now, if I may, first of all, Sarn, thank you for the super chat. If I may anticipate the answer is going to be if the Senate and the House abuses of their powers to impeach, they will suffer the consequences at the ballot box.
And also,
Yes.
treason is explicitly giving aid and comfort to
Fine.
the enemy or committing rebellion against them, period. End of discussion, because it's in the Constitution. So
During
none
time
of
of
those
war,
things.
though, right?
And
Treason.
during time of war. Treason is only during time of war, right? Aid and comfort to the enemy during time of war.
I don't
No?
know off the top of my head, but either way, whatever.
But either way, yeah, it's defined in the Constitution.
And I guess the bottom line is, even if Senate or the House and Congress colluded to impeach an independent president they didn't like, if they did it in an abusive manner, they would suffer at the ballot box or a revolution, whatever.
I said it on my
but they're
stream
sure it's
yesterday.
illegal.
As far as I'm concerned, legally, the House can jot on the back of a cocktail napkin, "The president is hereby impeached because it's Wednesday and we're bored," and the Senate can vote on it, and it would be legal.
Yeah.
Whether it's a good idea, pragmatic, whatever, there's a whole nother set of worms, but they have absolute discretion as far as I can tell.
Don't you usually make that joke about the, like, he makes the joke about if you're at the what is it called, the with the president, what's it called, the State of the Union?
Mm-hmm. Yeah, because everyone's in the room.
Yeah.
We'll just do a quick hand vote. Hey guys, what do you think? You want to impeach this guy? Yeah, probably works.
And you're gonna impeach him that's at the House.
Yeah,
Impeach,
that's right.
convict. All right, he's gone. New president.
Yeah,
Yay!
But it is amazing. I mean, what's fundamentally amazing is that there are two diverging theories, and they are radically opposed. And there's a ton of people who would adhere to both of them. It's just it is actually phenomenal. The bottom line is, it doesn't matter what you think, just why you think it, and you can disagree on the conclusions so long as you can agree on the history and understanding of the basics. Dude XO1. Many people are complaining about the no witnesses vote. Good. Let's get to this. But isn't it like motion to dismiss or directed verdict? Who wants to start with this one? Because I should probably not chime in.
Well, you know what? From my experience in criminal law, it seems to be like after an indictment, you have your indictment and you've been formally accused, and then sometimes when you go to the trial jury, there's what they call a preliminary hearing, and a preliminary hearing kind of does the same thing where you kind of evaluate the evidence and see if you have enough here to actually proceed to trial. You evaluate the witness, you have opening arguments, you evaluate the evidence, and then the judge makes a ruling that yes, you have enough to go to trial. And if you lose, if the prosecutor loses at the preliminary hearing, the case is over. So that's kind of what I'm thinking about this first part is like the preliminary hearing. Let's hear the evidence, see if we have enough to even hear from witnesses. And that Senate seems at this point saying, well, we don't need to hear anymore. We've because most of the senators now are saying there's nothing to prove. They've proven their case, but it's just not enough to impeach, and that's why they're going to stop it.
Yeah, I think it is kind of equivalent to a directed verdict after the prosecution rests its case. If the prosecution hasn't proven the case, the defense can, before it starts its case, just say, move for judgment. There's not enough here, so move for a directed verdict. If it's true, they'll say, okay, not guilty, end of discussion. So the House came if the House are the prosecutors, they came forward with their case, and they offered their case, and of course the defense lawyers are making arguments too, as you would expect, because of course the defense is participating when the prosecution's offering. And so they're finished their case. And so if the Senate, as the judge, wants to say, okay, well, they didn't make their case, so we don't need to hear anymore. We don't even need to hear from the defense. They don't need to open their mouth. Then it seems like a directed verdict, I guess, would be equivalent.
Okay, well, now, and this is where I've taken some issue in terms of clarifying what I think is a misconception. Many people are complaining about the no witnesses vote. So my understanding is that they were not not necessarily like proceeding to a directed verdict, but what they were saying was, we're going to see if there's enough of a case to even move forward to a trial which might require witnesses or additional witnesses. And if we don't feel that there is, the parties can just proceed to argumentation based on the evidence that was adduced before the House. And I don't think I'm wrong on this, that it's not a case as though when someone says no witnesses, it's not as though there was no witnesses. Each and every one of the witnesses that testified before the House with all of the evidence that they adduced during their testimony could be brought back up in pleading before the Senate. And so you could have Vindman.
That whole record has been entered into the Senate's record.
Yeah. So
to say there's no witnesses is not fair. The House called, how many witnesses did they call? 20,
I think they called 11 or 12.
11. Okay, so the House called 11 witnesses, and they can argue from the record as though they offered them live testimony, because That's what we did. So they said, here's our 11 witnesses and the testimony they've provided, and here's our case as the prosecution. And incidentally, we'd like to call more, but I think you could view it as the trial has been ongoing. The record of the 11 witnesses are there, and we're having argumentation about it. And I think it's more like a directed verdict. But I mean, you could view it differently. You could view it as quasi grand jury. There's other ways to view it conceptually.
Well, the analogies, they're good to the extent that they facilitate an understanding, but they're bad to the extent that they're analogies. The bottom line is that I take issue, and my stomach turns every time I hear someone say they're not allowing any witnesses. Every one of the witnesses that testified for however many days before the House, and I did 7 vlogs on it, all of that witness testimony was available for pleading. So when the House said, we have an ironclad case, let's vote on the articles, move it to the Senate for trial, that's the evidence that they still get to rely on. They just don't get to necessarily.
And as a conservative, I do take a little notice. It's a little bit hard to take the position simultaneously. We have an ironclad case, and we need new witnesses.
Well, and that may be a talking point, but
what?
That may be a talking point that some people are going to disregard. But the only thing I take issue with is actual factual qualifications. We're not allowed. They are not allowing any witnesses before the Senate, so it's no trial. They are allowing, as far as I understood it, and someone can correct me if I'm wrong, Vindman, Sondland, what's her name? Yovanovitch. I don't. Every single one of the witnesses who testified, all of that testimony and evidence is available for the trial before the Senate, and they can rely on it. What they would basically be saying is we can't have them retestify to ask additional questions, which they could have voted on if they wanted to, or additional witnesses that they didn't call. Bolton, for example, setting aside the fact that they never subpoenaed Bolton in the House, whatever might be a talking point. But the bottom line is, I get irritated, and I sort of get my knuckles clenched when someone says no witnesses before the Senate when they have all of the witness testimony they had before the House. That's part of the record before the Senate, just pleaded. So even now they've been deprived witness testimony. They can still plead all of their original witness testimony that they had for this. I don't know how many days it lasts before the House. That's all in the record, and that's all witness testimony in the record. They can plead, invoke, and rely on.
But it's I don't know, because let's say in a criminal case issue, everything at the grand jury you can make available to the trial jury. All those witness testimony. You're going to have witnesses testify at the grand jury. You're going to have notes. You're going to have all that stuff, and you can present it to the trial jury. But you still want to have that trial jury, because it's a different body, hear your live witnesses, because again, they're assessing witnesses based on law and fact. The way the witness talks, the way they recant their story. That's the reason why. If they just said, well, you had them testify at the grand jury, I'm going to say, well, that's crazy, because now I have a whole different sort of people that I have to convince to these new facts and evidence. And and just to say that you people can read the transcript of the grand jury generally isn't enough. So if you had a grand jury,
quite follow here, because of course the grand jury in this analogy was on TV and everyone saw it and watched it, so they did get the opportunity to view their demeanor and all that stuff.
But seriously though, you can watch if Florida had the sunshine laws, everybody can watch the trials on TV. But as a lawyer, you want to have your live witnesses at the if they're going to rely on my grand jury testimony, that's nonsense. I'm saying I need live witnesses, because I'm trying to prove to the petit jury that this person's guilty, and that's a factual matter.
Okay, well, I mean that's interesting. Then the question is, because the argument over the witnesses, and it's confusing. It's not necessarily calling new witnesses, but calling the witnesses that have already testified before the House to testify again before the Senate if there are additional questions or whatever. And then the secondary question is additional witnesses that they never called before the House before they actually approved the articles of impeachment based on the evidence they had. And they say, well, now we need more evidence to actually convict. We approved on evidence that is insufficient to convict. So now let us call more witnesses so that we can, what's the word in French, but so that we can satisfy the weaknesses in our file for the purposes of conviction.
But again, the analogy to criminal law, and this may be because I'm a criminal law guy, but that's the way it usually works in the criminal law stage. For the grand jury, the standard of evidence there, is probable cause, which is more or less the lowest standard for a grand jury. You just got to show that it's more likely than not that this person committed it. But the standard at the petit jury is beyond a reasonable doubt. So for the grand jury, I don't present all of my evidence. I don't present, the reason why I don't do that is because I preview a case, but I don't give you everything, because at the petit jury, of course, I want to give you everything because that standard's going to be higher. And on top of that, I have, now instead of just getting a 50% vote, I got to get 2/3 to be convinced. So I do need additional evidence. I do need it. If I can make the argument that these people are relevant to a petit jury and maybe not to a grand jury, then the judge is going to give me those additional witnesses because I have a higher burden to prove. It's not the same as it is, if the evidence, if the burdens were if the standards of evidence were the same in both, then yes. But even at like a grand jury, you can have hearsay evidence. You can do so much more at a grand jury that you can't do at a petit jury. That's why, even though the process is linked as one, they are fundamentally two different processes.
It's interesting. That's I heard another lawyer, Mike Cernovich. He did a live stream where he says that you can't even analogize. You can make an analogy, but the impeachment is sui generis, one of a kind. You can't compare it to anything. And there's the expression, you can indict a hand sandwich, but I don't think you can impeach a hand sandwich type thing. So it's interesting. The analogies are there. The only question is, how far do the analogies go before they start to fail for logistic reasons? I hear a kid crying upstairs. Does anybody else hear a kid crying? We got one sick kid of the three who's not asleep. Okay. Barely am here says, can the impeachment be expunged? Anyone placing odds? It can't be. From my understanding, he will always be impeached, regardless of whether or not he's acquitted.
Yeah.
When Andrew Jackson was censured over the Bank of the U.S., that was
expunged. It. They expunged that, but
I've never heard.
That's how we know about it.
Expunged.
I don't think you can expunge an impeachment. The censure, I see why they totally expunged that.
Okay, interesting. Let's see. Did I miss super chats? I know I missed some. I can't see them. Don't super chat them again. If someone can just comment to me with the cut and paste. Oh, here we go. Joel Tamburo says, "Is impeachment a legal proceeding? If yes, shouldn't due process apply?"
It's not a legal proceeding, and due process does not apply. That's why Judge Nixon, that's what he was suing for. He was suing because he didn't have due process. They didn't give me my trial. And the Supreme Court said, well, guess what? We can't even look at it.
And it's definitely not a legal proceeding now.
Well, hold on, but didn't Dershowitz respond to the due process argument in the argument it may not have been Dershowitz in his argument, but it was in the argument brief of Trump, where they mentioned that even in the context of removal from office, due process did apply?
There's pieces of, I think, fundamental fairness that apply, but due process does not you don't have a due process right in that political only. Well, let me do this. You do have procedural due process rights in the sense of they have to have the right amount of votes and they have to follow those requisite procedures to get you out of office. But any substantive due process rights, I don't believe you have now. Not in the impeachment process. Okay,
we got Scholar the Creator channeling what's his name? Steven Crowder. A high crime is a crime. Change my mind. I hear a kid screaming who's actually coming downstairs. Now we might.
Well, definitionally, a high crime would be a type of crime. Yes.
This may be the time that the live stream is going to come to an abrupt end. Hold on.
But we had some more topics to discuss.
Hold on. Let's see if there may be a kid coming in who may be talking croupy. Seems most similar to a demurrer without prejudice, but there is no exact comparison. I don't think any Senate should take up a House impeachment when the House process was clearly unfair. Discuss amongst yourselves. I'm going to duck out for 30 seconds just to see what's going on with a child, and I'll be back.
Okay.
All right. But it's interesting because I understand a lot of people out there. They are beholden to this fact that they feel like the court should be the ones to interpret what high crimes and misdemeanors is. And I know it's frustrating, but it's just not our system of government. And the reason why is because of the separation of powers argument that was trying to be made.
Right. And I think the ultimate problem that we point out a couple times is if the court has the power of review, the only way to get rid of a Supreme Court justice is by impeaching them. So if the Supreme Court has the power to review this, then
they have the ultimate power.
Yeah. So like the Senate can kick out their own just from a simple vote, so they can, because that did come up once where very early in the constitutional history where a member of the House, They tried to impeach someone from the Senate or in the House. They actually.
Oh
tried to
yeah,
impeach
and they wouldn't.
Yeah, and they
tried to
said no,
impeach a
you can't do
senator.
that because you can just kick him out, and then they kicked him out.
Yeah.
So,
Because
like,
the
yeah,
Senate could kick him out.
Yeah, so if the court can review it, the court can stop it, and therefore the Supreme Court is beyond any process to throw them out. This is bad pool, right? So there's process to get rid of everyone on some level, right? We have a process to get rid of the president, elections, and impeachment. We have a process to get rid of congressmen's voting or elections and the internal review to remove. And we have a way to get rid of the judiciary, impeachment. If you take away impeachment, then suddenly the judiciary really are king. So let's not do that.
Well, one thing I want to go back to is the argument for precedent. Now, there have been two, for instance, there were 2 impeachments for drunkenness.
Yes.
There were impeachments. There were like 3 impeachments for abuse of power, and one for disrespecting Congress, but for a presidential impeachment. And there was even an impeachment for and even Nixon's impeachment. One of the articles was abuse of power, and one of the articles that failed for even Bill Clinton was abuse of power.
Mm-hmm.
So to say now that abuse of power isn't an impeachable offense, I'm just trying to, even if I give you the argument that it has to be a crime, abuse of power is clearly, it's got a clear long history of being something that people have been impeached for. And even with the crime issue, people, being drunkenness, you had one person convicted of and kicked out of office, and a second person, when he was impeached for drunkenness, he resigned. So I think I don't know. It just seems like the precedent seems clearly that it doesn't have to be a crime to impeach.
So the drunkenness for the Viva. Just wanted to thank you for bringing up these guys together to educate me. Much appreciated. This is phenomenal. I mean, it's phenomenal.
I'm having a great time.
No, it's great. The only thing that's driving me nuts is now I see comments about the coronavirus. And yes, when my kid got sick, I must tell you the first thing I thought was coronavirus.
Seems unlikely.
It's very unlikely. It's just a bad flu. Okay, the drunkenness. So there's 2 things here. These are a number of arguments that people have been raising on both sides. The drunkenness, some people might say drunkenness, there are certain laws that probably get violated in terms of public drunkenness, drunkenness during execution of duties, so on and so forth. So it might actually have been a crime, and it might be a partisan talking point to oversimplify it to say mere drunkenness. So let's deal with that one issue first before we go on, because I know there was Robert Barnes brought up the judge who was charged on drunkenness, and I think it was Chase.
No, Pickering was the first judge he was convicted for drunkenness, and then you had one right after Johnson. After Johnson was acquitted, the next impeachment was one for another judge who was drunk. So
now drunkenness on the bench. I imagine it is also a crime. It's not just a question of drunkenness on the bench. Drunken during execution of federal duties is probably a crime. So that's the first question I would ask. It's not just drunkenness, but rather criminal drunkenness, so to speak. If nobody knows.
Well, I tried to look it up after I spoke to you earlier today. I tried to look it up, and my first response to this, and Kurt will know this, is that drunkenness is probably not a federal crime because of the police powers of the state. There's a doctrine of police powers of the state. So, for instance, like there's certain laws that the federal government can't pass because it's the 10th Amendment gives the police powers to the state. And drunkenness is one of those. So even when I was looking at it, I was only able to find state statutes criminalizing drunkenness and public intoxication. And even in those state statutes, half the states consider it to be violations, not criminal acts, and half the states consider it to be criminal acts. So even so I have found no federal law against drunkenness, except for like the one that you showed me about the military, the code of military justice, where people who are in the military and stuff. So, but I would then say, even if it was a crime, drunkenness, you have one in drunkenness and abuse of power.
Okay, so now, but this, so let's put that in the parentheses. The first issue, the drunkenness examples, I still think there is an underlying crime, albeit either state or some sort of military or whatever. I suspect there's probably an underlying crime to the drunkenness. So when someone says drunkenness as though to say it's not a crime, I suspect it probably was. maybe not serious and maybe not serious enough to warrant impeachment, but nonetheless an underlying state or federal crime potentially.
Well, can I push back on that just for one second too? Is that in both those impeachments of both those judges, both Pickering and I think the next one was English, the arguments from the Democratic Republicans, the people who wanted to keep those judges in, were the fact that they weren't being charged with crimes and that these were not high crimes and misdemeanors, especially in the Pickering argument, because Pickering was insane. But the argument from the Democrats who voted against his impeachment and voted against him in the House, for him in the House, they said particularly that these were not crimes, and that's the reason why they were voting against it being impeached.
Now, well, that's a very interesting argument to begin with.
that was their argument. That was the argument that they were making. And
then the question is going to be whether or not they were not crimes, or they were not high crimes, because I would love to know the stats at the time, and I don't know, but I know that public drunkenness has been illegal for a long time, up until only recently. It's been decriminalized. But then, so that's one issue to look into. That's just the query that I had. The next one, the abuse of power. I would like to see one example of impeachment, judicial or other. I don't think presidential, no, but judicial, where the abuse of power was not itself coupled with the crime. Because this is what I was joking to myself earlier. Abuse of power, it seems to necessitate a crime, because if you can't abuse of something if it's not improper to begin with. So it's either proper use of power or beneficial use of power. But it seems to me to be abuse of power, there has to be a subsidiary crime to it. And in all the examples that I've seen of impeachments wherein abuse of power was one of the charges, they were always coupled with other actual crimes, which explains the abuse of power, which is using criminal activity to impose one's power. That's
agreed. But let's say this. Let's say if they were acquitted on all those other charges, but just convicted on abuse of power.
I think that's a false premise. Like they would never be convicted on the abuse of power if the underlying abuse was never proven. So the abuse of power would be extortion or intimidation or some other underlying crime. Whereas if you take away the extortion or intimidation, it's not abuse of power. It's just negotiations from positions of power, which is what I think a lot of people are viewing this particular impeachment like. Where show me the underlying crime, show me the extortion, show me the bribery, failing which it's just good diplomacy.
The thing both Nate and I had commented on, I think, when we were talking amongst ourselves earlier, was we were both a little bit amazed that they didn't charge any kind of crime, because even the Congressional Research Service has given up trying to count how many federal crimes there are, not just U.S. Code, but CFR. It's like, give me a copy of the U.S. Code and CFR, and I'll find 5 crimes to charge anyone in the room with. It's so the fact there's nothing here is amazing.
But that some people might accuse me of political bias, but I have none. That's where some people are going to say, well, they didn't mention any crimes, but they should be read as crimes. Like, no, because
or we could just actually say, according to 18 USC, fill in the bad blank. Yeah, it says this, and therefore that's bad, and we should do something about it.
Well, no, they didn't allege bribery. They didn't charge him with treason, which have criminal criteria for establishing the mens rea and actus reus of the crime. They didn't do it, and so that was the fundamental problem. It's like abuse of power based on what underlying criminal activity? Because if there's no underlying criminal activity, nothing makes it an abuse of power. It just makes it a use of power, which is basically diplomacy and good negotiations in general, is negotiating from positions of power.
Yeah.
Well, so the one thing I'm not sure, because abuse of power, from what I've been seeing, has always been its own article of impeachment. And you're right. I think even with Nixon, they had the underlying crime. With Clinton, they had the underlying crime, but they didn't charge power. But there's a judge that they just charged. Oh, matter of fact, there is one judge that they just charged with abuse of power. I forget the judge's name, but his sole charge for the impeachment was abuse of power.
Yeah, okay.
But I'm not sure if he had an underlying crime.
Well, that's the other thing. Is like when I was reading through Trump's argument brief, and they said I think the wording was virtually all or almost exclusively all of the judicial impeachments have alleged an underlying crime. And I asked Robert Barnes, I said, what was the one that didn't have an underlying crime? Because that's I'd like to go from the exception that undermines the point and not the exception that proves the point. And that it was one of those examples where they said it was just so, everything else was so egregious and exceptional in the circumstances. But if you have 1 in 100 and there's only one that alleges abuse of power with no underlying crime, yeah, then I would accept the other 99 as precedent that you need the underlying crime, which was lacking from these articles for whatever the reason. And I'm going to say it right now because a lot of people are watching. Jonathan Turley's argument was particularly convincing on that. Take your time, build your file. There may be impeachment-worthy acts here, but get them done before you rush through this, and they didn't do it. And why am I calling out Jonathan Turley? I want to do a live stream with Jonathan Turley. So everyone can tweet this section of the stream to him. I want to do a live stream with Jonathan Turley. I want to talk to him about these particular issues. Take the time and build the file to allege what is required, and don't rush it through for political reasons and then suffer the political fate you suffer.
There is a saying, which I'm sure you've heard, Viva, which is when you're going after big game, you better get it in one shot. And,
I've never heard it, but I know I took my firearm safety course. It's a good expression.
Yeah, if you're going after Capone, you got to have it down solid. And same kind of thing here. It's like they came with this weak kind of sauce. They could have subpoenaed a lot of these people. They didn't, and they didn't for reasons. They could have waited for the process in the courts to finish, so they determined whether or not they had to testify, and they didn't. They rushed it for political reasons because they didn't want stretching into the primaries. So yeah. I think that's reasonable. I think the way it was done was political, not because they may have true belief that he should be impeached for justified reasons, but at least the process in the House was political.
Well,
of course.
Sorry, go ahead, Nate.
No, I was just agreeing with you guys. I think this impeachment, I think we can all agree this was a bad impeachment, and it was rushed, and it was done. They were trying to get the timing right. We want to do it early enough so we can do some damage, but not late enough so it doesn't hurt our candidates for president. Right. And it's obvious to say, and if this was a real impeachment, they would have sued John Bolton in court and waited for the court to get back and say you have to testify. But obviously it didn't, because they had the political motive. So you guys are 100% correct with that.
I think from what I understand, they withdrew their subpoena for Bolton. It wasn't even a question of not waiting for the judicial to adjudicate on the validity of the subpoena. They withdrew the subpoena. Okay, we got Michael P says, Viva, fellow Canadian here. The impeachment circus has left me with the impression that at the very least the rules need to be clarified and or revised. Who would have the power to do that, actually? Like, could you have a constitutional amendment to clarify what is meant? Sure.
You would have to have a constitutional amendment to tell you what it actually means. Okay. And even in that, the court, all right, there's a famous case of 14th Amendment. What happens is that back in the United States, you know how we have our Bill of Rights, but the Bill of Rights didn't apply to state conduct. So the Bill of Rights, so for instance, your freedom of speech, your freedom of all that, state governments didn't have to give it to you. It's only the federal government. So they passed the 14th Amendment. It was a whole bunch of stuff. But one of the parts of the 14th Amendment, what was it? It was the Privileges and Immunities Clause. Mm-hmm. And this was passed specifically to overturn a Supreme Court ruling that didn't didn't incorporate the Bill of Rights to the states. Yes. So what happens is that
slaughterhouse cases.
Yes. So then what happens is the Supreme Court, because and to show you how much it's so, when they were arguing to have this amendment put up, they literally brought the case up to the floor of the Congress and said, look, this case says this doesn't apply to the states. So, we're passing this so it applies to the states. And as soon as the Supreme Court read it, after it became the law in the Constitution, the Supreme Court read it out of the Constitution. They said, this is not what it means. It means something totally different. It's not that. And we're going to leave it like that. So they literally read it out of the Constitution, what they had specifically put it in for. They read it out. Yeah. And that's the power. And that's why some people say the Supreme Court is the most powerful branch of government, because no matter what the document says and no matter what the history is, they get to tell you what it means today.
We definitely need to do a stream of the slaughterhouse cases someday. We can add to the list of cases that I don't like.
Forget that. I think Nate just proved his own point that the Supreme Court can, in fact, say what high crimes and misdemeanor means.
Yes. No, you're right. You're right. They are the person who can say it, and you know what they say? Ask them.
Touche. Okay, we got Mr. Helpless. Mr. Hellspawn says important question, important image question. Is it over yet?
Wednesday.
Long, short. It's over, but it has not. It's not over yet. Nothing's
Wednesday
over.
Until the next one.
Yeah. No.
So the only question left is, assuming Trump is reelected, when does the next impeachment start?
It's not. I'm predicting this. There will not
be starting now or after the election or what?
There will not be another impeachment effort. My only thing is.
No, there's gonna be at least one more.
Yeah, it's probably gonna be. If he's reelected, they're gonna impeach him again.
Convinced.
Bets, people. Let's take the bet right now. We're on. I keep hitting my mic. There will not be a second attempt at impeaching Trump.
Well, one of us is going to look foolish a couple of years from now.
Oh, they did get him again. I think they'll get him. If he's reelected, I think they'll get him again.
Yeah.
Okay. Now I know I missed a couple here. Luis Ray, thank you very much for the super chat. By the way, okay, we got Lokai. Thank you very much for the super chat. I love these avatars. I know I missed one here. I apologize if I didn't get it. Matthew Chris, there must be a crime. Abuse of power is not. DeLahaye was not impeached. Articles not drafted, no crime, no impeachment. Now, admittedly, he's got to fit this comment into the character limitations of a super chat. DeLahaye. You guys know what he's talking about? Who he's talking about?
DeLahaye he was impeached right after Andrew Johnson, but he was impeached, but he resigned before they had the trial.
So interesting, because then we may have examples of impeachment that didn't allege an underlying crime, but somebody says, I don't want to sit through a trial for whatever the reason. Let me go home. Do they get pension if they resign before being impeached?
Yes.
Okay,
Yes.
well, that's a good reason.
Yeah.
But Matthew, thank you very much for the super chat. Okay, I think I missed a couple. I'm sorry if I did. BB?
No, but the point, and just so the people understand the point of the precedent is that the precedent, we have people being impeached and convicted for drunkenness. We got people impeached for abuse of power. We got people impeached for all these different types of things. And just like back in Bill Clinton's era, where I can get the clips of the Democrats narrowing impeachment to the highest possible crimes under the most dire conditions. And the Republicans were saying, hey, there's no law that says that, the law is clearly on our side. We can impeach for anything. And now with the shoes just flipped on the other foot. And again, when the Democrats being impeached again, we're going to have the arguments reversed again. Because again, I understand it's an uncomfortable truth, but the truth is the Supreme Court has no role in impeachment and cannot define what high crimes and misdemeanors are because they are the ones saying it.
Impeach for obstruction of impeachment. I mean, that's where we're at in life right now. It's amazing. That's quite funny.
Now we move on to other topics.
Yeah. No, dude, we're an hour and 47 in. I know. How much more can we deal with here? So I really do think we covered everything. We covered the witnesses. We covered the Bill Clinton argument or the Bill Clinton impeachment argument. We covered Dershowitz. We covered the witness testimony. Did we miss anything from the comment section in terms of any lingering questions that people have about the impeachment?
I see people saying they hate me. I'm sorry.
Nobody hates anybody in here. First of all,
I saw some hatred towards me. I saw some people saying you're the greatest Nate, and some people there's a diversity of opinion as to who's the idiot.
No one should hate anybody for an eloquently explained diverging belief. Period. No one should hate anybody for terrible legal advice. Who just said terrible legal advice? I saw that. So no, what happens now is they said we're not going to call new witnesses. Now they're just going to vote on the issues. But like when they say they want to vote by Wednesday, as far as I understand, Democrats can now replead all of the evidence that they had before the House and hope to convince 2/3 of the Senate. Am I wrong?
Yeah. I mean, they can do that. Sure.
You missed two other super chats.
Yeah. Hold on. Let me go back here. I saw this one. Okay, Luis Ray, we got that. Thank you very much. Now, there was one that had a question in it. Dapper Dave. I know a Dapper from Montreal, which is very weird. Can also have an impeachment of a senator. So by your logic, Strom Thurmond, age 100 when alive, impeachment charges can brought against him based on argument of him not being of sound mind, no crime. Okay, I think we know where we're going with those. And Dapper, thank you very much for the super chat. I'm going to bring it out so we can see the faces of Nate and Kurt. Okay.
No,
And-
you cannot impeach a member of the House or the Senate. However, each House can throw out one of their own members internally. So you don't impeach it. You just do it by a House vote in the case of the House or the Senate in the case of the Senate.
But no, because I agree with that. But I disagree with you can't impeach them. I think you can impeach them because what wasn't there? The senator was impeached. He was impeached by the House, but the Senate refused to do the trial because they said that we can expunge him from the Senate ourselves. In other words, they rejected the impeachment.
Well, that was part of my basis for saying you can't. So maybe we're just reading that differently.
Interesting.
So,
all right, because they did impeach him. That's why I'm saying I'm just
I tried.
They did, but there was no trial. All right, cool. I understand.
Yeah.
Okay, we got Thamos Loop, which I think is a French name, which means magnifying glass. Has there been any other impeachment that did not include a statutory crime?
I think so.
So
Yes.
we've had the three examples: the drunkenness, which were not. Oh, sorry. Yeah, guys, go ahead.
Because as far as I was aware, every other impeachment had at least one crime element in it. Is that not correct?
Except the one drunken judge who resigned because this is from what Robert Barnes told me in our live stream.
The impeachment that went to the Senate, I mean, that actually made it through the House. Was there ever an impeachment that made it through the House to the Senate side that didn't have at least one criminal element in it?
Yes. There's been, I think, three. There's three of them that have, and there's been a whole bunch that had both criminal and non-criminal elements. Like for Andrew Johnson, one of his was the 10th one was disrespecting Congress, but he had and some of his other ones were criminal, but they really weren't criminal. It was crazy, but. Matter of fact, I think Andrew Johnson, you can actually make an argument that none of his was actually criminal.
So, the Andrew Johnson had he
violated the Tenure Office Act, which itself was unconstitutional.
But they found it to be unconstitutional.
Yeah,
but
at least it was on the books. It was something.
Yeah, it was on. Yeah,
but
that was his argument. His argument was it was unconstitutional too, and that's why he violated it.
Which
and of course, it was totally unconstitutional.
The idea in the Andrew Johnson, for anybody who doesn't know, and I learned this in looking it up, is that they apparently passed a specific law to specifically target an act that they thought Andrew Johnson was going to carry out in his role as president.
They knew he was going to fire
that guy.
Yeah.
Fire that guy.
And
we're going to impeach you for firing that guy. Yeah.
So they pass a law to prohibit what they know he's going to do. He does it, and they say, "Oh, look at this! You just violated the law.
We got him.
Impeach you."
Yeah, we got him.
You know,
and he disrespected us.
Remember? Yeah, and when Jonathan Turley talked about a manufactured impeachment in Andrew Johnson, I imagine now Andrew Johnson was very much like Donald Trump, like just despised by a great many, maybe loved by a great many, but like this was, let's find a way to get him out, and that's the way they were finding to get him out.
No, but understand why they wanted to get Andrew Johnson out, because it was one of those split ticket deals where you have Lincoln, the Republican, this guy, and they needed a conservative, somebody on the other side to kind of balance the ticket, so you can have those people who are on the fence vote for Lincoln. So when nobody thought Johnson would ever become president. But when he became president,
we thought it was a good idea for the vice president to be the person of the other party. That was good times.
Yeah, and when he became president, all hell broke loose because it was right after the Civil War. He was doing all these things, so they were like, "Yo, listen, we got to get this guy out of here." And that's why he never. And it was interesting because Johnson he never appoint a vice president for that same reason. He didn't have a vice president, right? Oh, I think he didn't. He didn't have a vice president because he was scared that they would kick him out, and they were like, you're not going to have another vice president.
This is what's amazing about all this, is that it's not just the law and it's not just the Constitution. It's like the actual history of the creation of America, which is phenomenally cool. Steven says libertarian view. I hadn't heard the word libertarian since I studied philosophy 20 years ago. And this is just another way to fit. Like when you're not Republican and you're not Democrat, you're libertarian. That's sort of like as the middle ground, I think. But that might have been a total mischaracterization of libertarianism. But
just to clear it up, Andrew Johnson had no vice president.
Okay.
Tab out what?
Libertarianism is just opposing government action, just pretty much period.
Minimal government.
You don't like the government doing anything in any context. So, don't get in my bedroom. Let's have pot. Everything should be deregulated. Blah, blah, blah. That's libertarianism in short.
One day I'll get my rant about why trusting government is just as dangerous as trusting private enterprise. But a topic for another day. We got Leaf Sandiger says, "Can Corona change the name of coronavirus to the Bud Light virus?" Okay, first of all,
Wishing made it so.
Thank you for this. Yeah, don't expect to see that as a Super Bowl ad tomorrow. That would be that would go down as one of the worst Super Bowl ads ever. John McLaughlin, Viva Frei, maybe do a breakdown of Dersh's lawyering tactics similar to the one you did for Schiff. So I didn't break down the lawyering tactics, but I did one breaking down his arguments. And one thing that I did find curious, if you notice his hand, can I see it? He did this. He didn't do the OK symbol. I noticed when he was pointing forward, it wasn't a Bill Clinton thumbs forward. He had his middle finger on his thumb, which I thought was weird. It was curious, and it was like sort of like in between not getting caught with the OK symbol, so you don't get accused of whatever, and in between the Bill Clinton thumb pointing forward. But I would have nothing to add for his delivery. But I did do a video like explaining his argumentation in detail and going through it. So if you haven't seen that, check it out. Let's see. That was John McLaughlin. We got Thomas Loop. Has there been any successful impeachment without a crime? And I know where they're going to go with this one, but Nate, Kurt, any successful impeachment without an actual crime?
Well, Pickering, the ones that everybody hates, the first one, was a successful impeachment and conviction without a crime. And when we say impeachment, I'm assuming impeachment and conviction, right?
Yeah. What did they convict him on, Nate? If I may ask you the question to which I know the answer.
Was it drunkenness and something else? Well, actually, he was convicted on all charges, but they didn't specify which charges particularly.
Okay, so that's the apparently he was convicted and removed without specifying the charges on which he was convicted. So that's Robert Barnes's argument to say it was such an exceptional circumstance that he was removed for drunkenness, for being mentally unthere. His kid wrote in to say he's crazy. He didn't show up to his own impeachment trial. And they just said, okay, we're removing him, but we're not specifying the basis so as not to create a precedent. That's the argument. Agree with it, but that was the argument. Okay, so I did that. I did this. Let's see this. Okay, has there been a seven? Okay, we got that. Then we got Mighty Mouse 9305. Can they bring evidence against Biden or others during impeachment? Well,
they could have.
Okay.
Yes, they could.
Were it up to me, I probably would have voted to allow Bolton to testify in exchange for getting, them to testify, get Hunter or Biden to testify, either one.
So now this is a question. So there was the issue of, this is where lawyers get detested, where the Democrats saying we want witnesses, and the Republicans are say we want witnesses too, and then the Democrats say, well, we want relevant witnesses, and Biden, Schiff, Hunter, Joe, who else was there that everybody wanted? Those aren't relevant. And that's where you get into like, nobody would agree to a trade, which is why I suspect the vote for additional witnesses didn't pass, because ultimately nobody wanted it. They just wanted to posture and pretend that they wanted it so they can get the political points for them. They wanted it, but they didn't actually want it. Because
I love that. We need to have witnesses. Only trials with witnesses are good, but not those witnesses. Yeah. So it's like, okay, if I'm the defense, I get to call anyone I want. If you want to object to relevancy of the witness, talk to the judge, which is the Senate. So it's like, okay, well, so I'll do you 1-for-1 trade. I'd love to hear from Hunter Biden and Joe Biden and probably some other people. So yeah, call Mulvaney, call Bolton. I'm reasonably confident in what they will say. That's not going to hurt my case, and we'll see what the Bidens have to say and go with that. Yeah. So if I were a senator, probably would have been my disposition.
Now, quick question: what if Hunter Biden takes the fifth?
Well, I don't know if he could take it as to every question, but I mean that has value in the political context, at least, right?
Yeah.
If he takes the fifth as to every question he's asked, well, that's good too. I'm happy for that too. That's like a win.
And for those who don't know, that's the amendment against self-incrimination. So if Hunter Biden's up there and they say, "Did you?" They can't make him self-incriminate himself, so they can say, "Hey, I'm taking a fifth." That'll be a hell of a story.
So this is the thing I like, because Legal put out his video and he says, and everyone's floating the same statistic: 70% of Americans want additional witnesses. It's like,
which witnesses? I
think we all wanted additional witnesses. The only question is, does it then go from an impeachment trial to just a trial of government? And like, everyone wanted witnesses. The only question would be, then it would turn into the fundamental double standard hypocrisy of, we want our witnesses, but not yours. Yours are irrelevant. Only ours are relevant. And that's the push and pull that you have in litigation all the time. It's like, oh yeah, that's irrelevant. Let me tell you how to run your file and let me run my file the way I want to.
But this is
and as you pointed out on an earlier video, Viva, the Republicans never got their minority day to have their own witnesses in the House side either.
Yeah.
That I still don't know how to make. So hold on. Joe Ward says, tweet Turley, everyone, for Viva at Jonathan Turley. Get Jonathan Turley to agree to a live stream. I would love it. That's something I never understood. So they never got their minority day hearing. They got one witness, which I think was Jonathan Turley, right? That was, I don't know what I did. I can't see my screen anymore. Okay, sorry. That was scary. The Republicans got one witness in the House inquiry hearing, and that was Jonathan Turley. Am I wrong about that?
Yes, they're constitutional scholar.
Okay. So they never got the minority day hearing. It's discouraging to see the politics being played because it's just dirty. It's just dirty stuff. Like, they didn't allow the Republicans to have their witnesses, and now they're complaining about not getting to have additional witnesses before the Senate when they already had all their witnesses before the House, where they said it was ironclad and ready to go, and let's impeach and let's move forward.
Well, hold on. But one thing
we've hit the 2-hour mark. I'm officially calling it. We can't talk about impeachment anymore.
Okay,
we can talk about the lawsuit. We can talk about whatever else, but we got to move on to our topics.
I was just going to point to this last question that you were going to. I'm trying to get to the super chat, man.
Okay, I accept my fate.
This was one more super chat.
Oh, we got this one. Please discuss Hillary and the DNC are in the clear because they paid for their foreign. Okay, separate video. Not a good argument to be raised. I think we can all agree on that.
Yes.
Okay, it's a bad argument. Because the idea there is that there was no bribery or abuse of power because they paid for their foreign intelligence. It's a bad argument. We don't need anyone to tell you that. But thank you very much for the super chat. I know I missed one down here. Sorry, I got fat fingers going on here. Why does the precedent for new witnesses matter, but the precedent of a minority hearing witnesses of White House counsel being president doesn't matter? I still have not heard a convincing argument for that. If anybody can explain that to me, I don't understand it, and I'll plead ignorance. Nate, Kurt, what do you think?
I think they're just talking about that the White House counsel wasn't present during the House side and the hearings on that, and that's different from before. And the minority hearing not happening is different from before. So they're saying, why do some precedents matter in terms of the House procedure or Senate procedure, and not other precedents matter in terms of the procedure? Is basically what I'm hearing in the question. Because reasons is the answer.
Yeah, because but one thing though is that this would be like the first impeachment trial without witnesses at all. The other ones all had witnesses, so I'm not sure if you're talking about the precedent. The precedent is they should have witnesses. No,
well, the precedent was there was a minority day hearing during the Clinton impeachments, so the minority Democrats at the time had their witnesses. This time, and I remember noticing it's like Nadler's banging his gavel saying, that's a non-cognizable point of order. We'll get to it. And then they approved the articles of impeachment before they got to it. And then people like in subsequent videos like, hey, dude, whatever happened with that minority day hearing? I was like, I don't know. You know what? It's a good point. Never came up. They never got their witnesses. And so how do you get past that? I don't know. And I'm open to legitimate explanations as to how that can be explained away.
No, maybe I've never looked at the precedent for the minority day hearings, but I know, like, at a trial, generally you would have witnesses. So maybe that's the kid. You didn't give us that in there, and no legitimate basis to claim injustice when you got all your witnesses. You can still have those same witness testimony, just not viva voce, but you denied us our minority. It's a problem. Thomas Loop says, I know nothing about law, but you brought up the grand jury earlier. How much input does the defense have in a grand jury? They generally have absolutely none. You can indict a ham sandwich. They have, but here in the state of New York, you can you can force your way into the grand jury where the defendant can come and give notice that he's going to testify to the grand jury. But again, I get to ask him all the questions I want. I get to give the grand jury the law. Like, it's totally controlled by the prosecutor, so it's a rigged game. The grand jury is a rigged game.
Okay, very interesting. JC, libertarian in general, constitutional or originalist. The role of our government is to protect our rights, not regulate or violate our freedoms. JC, yeah, I agree. Man, and I'm living in Canada, and I can see the way things can go haywire when that's no longer the accepted principle. Choivu says, of course they bring evidence against Biden because this is not a court case. Of course they could bring evidence against Biden because it's not a court case. Yeah, but you would definitely have the Democrats saying that's not relevant to Trump's impeachment for abuse of power. Doesn't matter the why, it's the what with respect to Trump. And you expect the lawyers to make the argument. Don't hold it against them.
Motive.
It goes to motive. I think it's relevant because it does go to motive. It does go to motive.
It goes to the underlying national interest. This is one thing we actually, first time we're touching on it. The one thing that I've been saying from the beginning, it's not because it also could potentially or obviously serve Trump's interest for being reelected, that it's not in the national interest to discover fundamental corruption in foreign countries that's being subsidized by taxpayer dollars. So the two can mutually coexist. The successful thing that they've done from the beginning is created this dichotomy that it's either in Trump's interest or it's the national interest, where there's entirely plausible it could be in both. Like, okay, first of all, it is in the national interest to get a very good trade deal with China or Canada, for that matter, or Mexico. It would also necessarily be in Trump's personal interest to get that very same favorable trade deal. So these two principles can overlap very easily. And the successful framing of the debate from the beginning was that it's either in Trump's interest or it's in the national interest, and it can't be both. Yeah, that's my rant. Sorry, I'm done. So we've got the Bidens. We got Matthew Chris says, if HB took fifth,
Hunter Biden.
Senate could force testimony, listen to verdict with Ted Cruz. He explains. Could they? I don't know about that. Could they force
they have
someone
to grant him immunity?
They got to get him immunity for all crimes. Yeah. I'm not sure if they can do it, but he would get it. But they would have to grant him. They can grant him immunity. That's the only way. He would have to have transactional immunity or something.
Okay, very cool. Right here. What we got? Green. We got, I wouldn't call Turley as a witness, at least not in the what the F happened context. No, Turley was there as a constitutional expert, and between him, Feldman, and the other person who will cross the street to avoid Trump Tower, what was her name? Someone will get her name.
Oh, yeah.
Between the three of them, I think we had our most compelling constitutional scholar, and I don't think that's a partisan thing to say. Okay. Gentlemen, I don't think we're going to cover another subject tonight. I think this is just going to be the most in-depth breakdown, update, analysis of where we're at as of today.
I'm sad.
Oh, come on. Don't be sad on civil. Kurt, it gives us an excuse to do this again next week. I wanted to deal with Willie Nash.
Okay, I withdraw my objection.
We can, dude, although we need next week, we're going to have one more square. It's going to be Leonard French, top right, giving a $2 shut it on impeach, do Tulsi lawsuit. Oh, well, Tulsi lawsuit. I've done Tulsi lawsuits. I read through it. I did the service video, which was fun. And and I announced the podcast, my podcast. It's called Viva Law Podcast. That's what I ultimately
went with.
How's
that distinct from what you're doing already?
It's going to be slower pace, and you can take it where you go with you, as opposed to YouTube, which you need a computer for. Okay. That's the space. It's going to be I'm definitely going to slow it down, maybe get a little more opinionated, not in a shocking way, just like it's going to be a more personal conversation, except you're just going to listen to my beautiful voice.
Well, if you need some help on that so you don't get completely overwhelmed and everything, let me know.
God.
About time.
I'm overwhelmed as it is, but I may take you up on it, Kurt. So I did Tulsi Gabbard. I've got 2 videos on that. I don't think, have you guys touched on Tulsi yet or no?
No, but I do want to cover the lawsuit because I thought I agreed with your opinion. It's really, really good. So one of these times I'm going to go through it and really go into detail because it was a really good summary of the law.
Yeah, it was. First of all, I saw BB Super Chat. Thank you very much, Soup BB. It was great because the one angle that it drives me nuts that I didn't actually think about beforehand was that when Hillary Clinton, given her history in government, says that someone's a Russian asset, a lot of people can assume that she has more information than the average person to make that statement, not less. And therefore, it carries more weight than it would if I said it. And That is someone says you always sound like you're on crack. You slowing down is still so yes, you distracted me because I saw crack in the super chat in the comment section. Yeah, that particular point was very poignant to me. Like it wasn't. I don't want to throw out names to insult other people. It wasn't anybody else saying it. It was former Secretary of State, former First Lady saying it. It carries more weight, and that's a damn good argument to say it's not. It's beyond reckless to say that if you don't have evidence to substantiate it.
But that malice is going to be tough, boy. It's just she's a public figure. She's going against Democratic, and she's saying she's a Russian asset. It's I don't know. I think this is nice.
This is impeachment for self-serving interest. Uncivil Law just super chatted, which is thank you, Uncivil. Thank you very much, Kurt. Subscribe to Uncivil Law. Amazing stuff. Nate Broady, amazing stuff. What I love is that this is. I'm going to keep it up there for a bit so everybody can see it. The thing about law type channels, it's not. There's no saturation of the market in the sense of like reaction videos. Once you've seen one, you've seen them all. You're getting different perspectives from different people, from different walks of life, from different educational, historical backgrounds that have their opinions on matters of law, and it is always going to be interesting to get the perspective of somebody else. And it's great. You got Uncivil, you got Nate, you got Ian Cortha, you got everybody who has a different view, and you can filter through whose opinions you think are ill-founded very quickly to filter on the ones that you think are good. And we're creating a market and like sort of a niche of
I meant what I said 2 hours ago and the long ago in the past, but I meant what I said. I'm hoping to create a new academy. And so I'm trying to drive a little bit by myself because I think this is an opportunity to be an educational platform for law. And why not? We can have people teaching about this. So I'm happy for the dozen of us or so that are involved in this field. I'm hoping to grow it. And I'm hoping to do even more collabs with more people. If Legal Eagle is out there somewhere, I just want him to know I'm happy to do a collab with him at some point too. I know he thinks a lot differently than I do. I'm sure it'd be entertaining, but
if you tweet him, he might respond to you. I think Legal Eagle.
Yeah.
I think my Captain Marvel.
I have to point out
you guys
that,
hated the Captain Marvel thing.
The channel, the video that was my tag channel. Like how you can have one that is like the channel for all you new people.
Yeah, the banner video.
Until very, very recently, it was Legal Eagle is wrong about Captain Marvel. Here I explain it for 50 minutes why he's wrong. So I don't know. There's a love lost between me and him.
You know the great thing is the Legal Eagle. The Captain Marvel. Scandal was before we had this impeachment. Like once this impeachment thing, that's where you're really getting to have substantive disagreements. The Captain Marvel was so superficial and childish. Like it was great. Disagree on some stupid interpretation of some scene from a movie, and now we're like having substantive disagreements on matters of national historical importance, and it becomes a little more personal if you want to take it that way, or it becomes just much more significant. But it's amazing. It's interesting, and it's something that everyone can benefit from. It is fantastic.
You got two more super. Oh, to let you know, here you got them.
So that guy just pissed over libertarians. Could you possibly do a video on libertarians in the U.S.?
I do have to apologize. I said it in chat, but I will apologize. I was a little flippant and short with my description of libertarians, so that was my bad. I apologize. I should have been a little bit more thorough, so I apologize for the misrepresentation.
Well, I think I may be insensitive a little bit because I didn't even pick up on it, but
yeah.
Always accept a person's apology if it is sincere. And yes, I don't think anyone was intending to take that too seriously. And I think that super chat also might have been tongue in cheek. But
I hope so.
Kurt, now you might have to do a video on libertarians in the U.S. because I'm not in a position to do that. I don't think. But John Stuart Mill. John Stuart Mill was a libertarian, right? Or was it John Rawls?
John Stewart wasn't a libertarian, right? He was
definitely not.
A lefty.
Who's the quintessential libertarian wwho wrote the books on philosophy?
Oh, I know you're talking about. Now I can't remember the name because you just mentioned it.
Someone's going to put it up in the comment section. But Kurt, in order to atone for your indiscretions, you may have to make a video on libertarianism in the U.S. now.
Yeah.
Locke. It was Locke. Okay, here we go. We got it.
Yeah.
It was John Locke.
John Locke.
I do
thank
like
you very
how I'm now being evaluated by the chat as to whether or not my apology was sincere or not. So that's
it's all tongue in cheek. Everyone here is in good faith. Okay, but no, dude, 2 hours and a quarter. We're
Ayn Rand too.
Ayn Rand. Yeah, Ayn Rand is the. No, but it was definitely John Locke, the one I'm thinking of, and Monty Python. Everyone agrees Monty Python was. No, sorry, I missed it here. Okay, let's do 2 more minutes to get any of the last questions. Other than that, this was phenomenal, dude. Yeah, we're gonna have to find some new subject matter after this is over because I've made my bet. But retrospectively, I'm taking 4-1 odds because I think it's more likely than not that there'll be impeachment. So I say no, 4-1 odds. Everyone's agreed that I get those odds. No, we could have some when they start having the presidential debates and even the DNC debates. We can do some stuff on that. I think
it's remember the State of the Union is on Tuesday, and they don't vote to acquit until Wednesday. So there might be
that's if they don't. That's if they don't agree to do it beforehand. They might agree to do it beforehand, right? Or did they already agree only to do it on Wednesday?
That's my understanding. It's going to be on Wednesday, as far as I understand it.
So hopefully Tuesday the senators will stand up and say, "We all vote to convict," and that'll be it. That'll be done.
I see what you were getting at, Dave. Okay, all three of you need to do a video on how to choose a lawyer. Okay, I'll do one. I'll do one when the news cycle is quiet and there's nothing that I need to tackle immediately. But I think I'll get to that. Oh, hold on a second. He says, "I gave you $2 and you didn't render the service." Fox Flames. You now have 2 minutes. Please post the comment. If nobody knows, I have a bit of like obsessive, tendencies. I will obsess over the fact that I missed the super chat. So, Fox Flames, please. What was your question? And let me see if I can get it in the next 2 seconds.
Yeah, this is a problem for you because you have so many super chats.
Yeah,
I do feel bad because I want to get to all of them.
They love you.
Fox Flames, Tulsi lawsuit. No, Fox. I done 2 videos on the Tulsi lawsuit.
Yeah,
I think we got.
Yeah, we discussed a little bit.
He wasn't here. He went out to do something and missed it. Okay, so Fox, thank you for the super chat. I did 2 videos thus far on the Tulsi. I walked through the lawsuit, paragraph for paragraph. It was good. I actually did a video. Sorry, now that I think about it, can Tulsi sue Hillary Clinton for the defamation? That was 3 months ago before the lawsuit was filed. So yeah, check it out. It was a good one. Tuesday is so that's why no vote. Yeah, that's the question. I thought they were going to vote before the State of the Union, but hold on. We got here I spent $5 and you didn't. You didn't. Monkey. Okay, what was the question, Monkey?
I think they just playing games with you now. Okay, I don't know.
No, that's what happens. This is now. Let's hear. We're not getting a news cycle. Then start using Russian notes. Okay. Has it been served? So I read, this is the Tulsi on Clinton lawsuit. I read that it had been served, but I have not found any independent evidence. But I think there's an argument that it's already been validly served. But we'll deal with that later. Sorry, we'll deal with that later. Okay, that was phenomenal, guys.
Yeah, that was fun.
I had a really fun time.
There's still 1,110 people watching this after 2.25 hours.
Wow.
And you are a hard man to get a hold of, Viva. So I'm really thankful that we were able to finally coordinate this.
No, it has to happen last minute because I can't plan in advance anymore. My life
is tough.
I no longer plan my own life. Okay, so Monkey says, that was my question. I spent $5. Okay, Monkey, that was the answer. 3 videos. I did the R word is what it was called. Can Tulsi sue Hillary for defamation? 3 months ago. Then I did the lawsuit. Then I did the service because the service is hilarious. Not getting to serve. World is a better place. Scott, I'd like to believe you're talking about all 3 of us and what we do. I will accept
we
that.
made the world a better place. Yay.
And then we got, how does Brady not apply? The Brady bunch.
It's criminal. That's a criminal case. This is not criminal. That's why. It's really simple.
Okay.
Brady deals with criminal issues, and this is not criminal. So Brady has no relevance.
I thought he was talking about the Brady bunch and that being Nate Brody's Broady bunch. Okay. This was fun. We got Joe Tamburro says, how would you legally approach the 3 questions at the pit?
What is your name? What is your quest? Was the philosophy of an unladen swallow?
I've never seen one Monty Python video in my entire life.
Oh, well, I think you probably should. I'd recommend Holy
Life of
Grail, I
Brian?
recommend Life of Brian. Life of Brian's probably actually better.
Was he? The thing is, all that I know about Monty Python, I learned from The Simpsons, and I think I know enough about Monty Python. So
fair.
it's like,
Yeah, it's permeated our culture. You probably got the point somewhere.
yeah, 100%. Like I'll know the lines before I see it.
Well,
Heresy. I maybe I shouldn't have said that, but I am brutally honest. I've never seen a Monty Python. What? Oh my gosh! I think now this is where I think I get canceled in this world. Okay, what do we got? Oh, Viva Frei says, I had a super chat that I had asked if the House could reopen a case over the call again. Okay, now this one I do remember seeing.
Oh yeah, no problem. There's no double jeopardy.
There's no such thing as double jeopardy. Yeah.
So on they can reopen on the same charges?
Oh yeah, no problem.
They can re-bring them back.
Oh yeah, no problem. Yeah.
There's no such thing. Because don't forget they're not going to put you in jail. They're taking your job.
Yeah.
That's why it's a lot less. It's almost it's a political matter, but it's more civil than criminal.
The party never ends. The game begins again. Just keep reciting to yourself.
Is there any disagreement on this? Because I find that answer shocking.
It's a political. It's because it's totally political.
It'd be like asking, once a bill fails, can Congress consider the same bill again? At least as far as I'm concerned. So the same exact subject matter, can they have another vote on it? Yeah. So can they impeach over literally the exact same stuff? Could the House submit literally the exact same words twice?
Or could they just do it again, but compensate for all of the weaknesses that they now appear to be apparent?
Yeah, I wouldn't necessarily recommend it though, because they're already in a really weak position. So I wouldn't necessarily recommend just wasting everyone's time, but I think it's legal.
Interesting. Okay, Keela Wolf. Thank you for the super chat, and I'm glad. Thank you for bringing that up because I did miss that. And I remember seeing that because I wanted to answer that question. Matthew Chris says Nixon versus USC 506 doesn't say Senate defines high crimes and misdemeanors. It only holds that Article 1 S3 CL. So high crime misdemeanor is defined.
Yeah.
Okay, dude, Nate, Kurt, we might have to do a specific video on Nixon.
All right. First of all, high misdemeanors. Black's Dictionary. Okay, Black's Dictionary is a tool. It's a useful tool, but it does not define reality, right? So just because it's in Black's Dictionary does not mean it is the law or controlling. So I'm sure Black's Dictionary has a definition on it, but that's not where we stop the analysis. That's basically where we would start.
Yeah, and the Senate
as to like saying it's non-judiciable, yeah, I agree. It doesn't say that the Senate defines it. It says it's non-judiciable, but from my frame of reference, what's the difference? So, yeah, okay, sure.
Well, we got. This is when you know stuff's getting real. Benjamin Semenker says, commenting under my real name, bold caps, to say you owe it to yourself to get Monty Python information firsthand and not from the Simpsons hearsay. Okay, so I think I may have to go fulfill something that's been missing from my life that I've never known is missing from my life. Drunkenness was impairing the execution of duty. Okay, that's an interesting point. Okay, dudes, guys. Okay, we're let's do this. Let's do this now. We're gonna call it. It's 2 hours and 22 minutes on the nose. This has been phenomenal. I keep saying it, and then look at this. Viva Frei's monkey question was the difference between actus reus and monkey's question was the difference between actus reus and mens rea. Okay. You guys, you want to do it? I mean, I could do it, but
sure. Mens rea is mental state, and actus reus is the actual action. So when you're looking to a crime, you normally have two things that you're looking to: the actual physical act or whatever, and the mental state behind it. So mens rea is your mental state, your intent, and the actus rea is what you're doing. So, someone shoots someone else is the act, but the mental state might differentiate that between murder, manslaughter, and a whole bunch of crimes. So that would be a good example.
Okay, here we go. Yeah, monkey. So we're getting to it. And yeah, I mean, so the act and the intent, because you can commit the act without having any bit of the intent. One would be, classic examples. You can commit the act of pulling the trigger, but if you're only doing it because someone's putting their finger on front of yours and pulling the trigger, then you have no intent to commit the act.
Right.
Trigger. So that's the
because someone shoots something else doesn't tell you anything about the crime they may or may not be guilty of. If they were doing it while hunting and the bullets swayed and someone got shot accidentally, it's probably not criminal. It might be because it might be negligent, but
it could be
probably not going to charge that. Versus someone's purposefully doing it is obviously murder. So you need the right mental state and the right action for you to meet the crime in most circumstances. There's not many strict liability crimes.
Yeah, and understand what he means by strict liability is that there are certain crimes where they don't have to prove the mental state, like statutory rape, for instance. Just because you did it, that means you'll automatically be held liable, no matter if you intended to do it or not.
And an interesting one in Canadian law, it's like one of the cornerstone criminal law decisions that they teach us in school is actus reus versus mens rea, where the person had the intent to commit the crime, and it was sexual assault. Except the victim was deceased, and so the question was then they couldn't commit the actus reus because it was no longer capable, but they had the mens rea of committing it, and they had to be charged and convicted of the lesser crime and not the greater crime. One of those, only these decisions get to the Supreme Court of Canada. We got Matthew Chris says, great live stream. I like lawyer pride, #lawyer pride.
Okay, I'm going to start putting that as a hashtag in my videos for a while.
100%.
I'm coming out as a
You
lawyer.
got one more that came in.
Say it again. Oh, here we go.
Yeah, one, yeah.
Jason L. Why would anyone expect Justice Roberts to be a tie-break vote? He's not accountable to the people, as the Constitution says Senate is. Am I wrong? I think you're right.
That's exactly right. And if it's a 50-50, that means it fails. So you have to have 51 votes for it to pass, because he will not vote.
That is the perfect time to end it. We're ending it. We're ending it now. There's no more exceptions. No more. 2.5 hours. Amazing live stream. People, thank you very much. I'm going to end the broadcast. Thank you for tuning in. We're still over 1,000 people, which is it's amazing. It's fantastic. I hope you all appreciated this. Chiefs versus 49ers. Joe Montana still plays for the 49ers, right? Okay, I'm done. I was waiting all night for that joke. Okay, we're going to end this. Kurt, thank you very much. Nate, thank you very much. Everyone, check out their channels. I suspect you know them already. And we're going to do this again. I'm going to end the broadcast. I'm going to say peace out and thank you for tuning in. See you next time.